approximately 1:05. The date is August 21st, 2024, and we have all commissioners present. We also have our city manager, Charles Wright, Don Holmes, our city attorney, Mark.
Correct.
I know, I always want to call you Mark Correct. Mark Correct, our city planner, and Karen Hayes, our clerk. Everyone's present, and with that, Commissioner Banks, I'm going to ask you to lead us in invocation. Please stand if you're able.
Father, once again, we come before you to give you thanks and to praise and to lift up your name. I continuously ask you to pray for the commission, pray for our communities and our attorneys and everybody involved in this city. We ask this in your son Jesus' name. Amen.
Amen. Let's do the pledge.
So you
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. I'm going to turn it over to Mark. I'm sure everybody had a little light reading.
I just want to interject, Mayor, the purpose of today is not only to hear the presentation about the finished product, development code update, but also to field any questions or discussion so that we're ready for first reading on the 12th of the ordinance to update the code.
Well, good afternoon. I don't have an extensive PowerPoint presentation. The only thing up here is the actual land development code. And so I'm going to try to at least keep my conversation as brief as possible. I know this is an important item, but I also have something else on the agenda that's equally important to the future after this. And I'd like to spend my time answering those questions so that September 12th, we know what the issues are and see if there's things that we can fix between now and then.
Today is about leading us into the future with this code and with our interim manager. Go ahead.
And since you last saw this, we spent a lot of time reformatting it, correcting typos, fixing tables, and as I was saying before the meeting started to the mayor, it's at the point where I don't know if I actually see any of the typos anymore. So if you caught any in that draft, we don't need to talk about them, but I'd appreciate you letting me know, and I'll tackle them before as well. And so I'm just going to touch on some of the things that I think are most important. First, I want to talk about the notice requirements. The city's current code is exceptionally weak in this area in terms of the notices that are given for the various applications. It relies entirely on the Florida statutes for things that are specifically mentioned in the Florida statutes. And if the Florida statute is silent on the notice requirements, the current LDC is completely silent. So for example, a rezoning, the only notices are newspaper notices. If you go to most communities, they have some type of posting, they have letters to the neighbors. None of that's in your current land development code. I know that Karen does post the property, but there's no requirement for her to do that. It's not mentioned in the land development code, and that's not a requirement of state law. State law, minimum requirements, put a notice in the newspaper. And so that is something we remedy now. The last draft you saw was a little bit better than the current code, but a lot of those notice requirements were kind of scattered and, for example, did rely on state minimums when there were state minimums that could be relied on. The current draft does still use those state minimums for things like the advertising requirements, but it has added posting requirements and mailed notice within 300 feet of the property. And so that's something that varies, from community to community. Some communities, it's just the adjacent property owners. Some communities go out 500 feet. We pick 300 feet. That's
Is
what
that's 300 feet from all the property lines?
Correct.
All lines are all-
Yeah, you basically put a buffer on it.
Can I ask you something about that, Mark? Because I read that in various places through here. And it was, we depended on and we would possibly ask that the applicant sign an oath saying they had done so. Is it typical with communities that we put that burden on the applicant and that we don't do it ourselves and charge the applicant just to make sure that it's done properly, correctly, and everyone is noticed as they should be?
It is typical. Codes used to be written so that was always on staff to do that. That's not common practice today. It's placed on the applicant. If an action is not properly noticed, the person that essentially, the remedy is to basically do it over again. And the person that, the applicant is the one that's harmed. And doing it this way, you're not creating a situation where you have both the citizens who have not been noticed or the applicant whose item, can't be addressed, just angry and focused on staff. So it is common practice now to place all of those requirements on staff. Now, we will tell them what letter they have to, we're not gonna just say, you go create a letter. We'll create a letter, say, here's what it has to say, but the burden's on you to actually do it. And I know there will be some applicants who will probably have to help.
I didn't read that we have a standard letter that they need to issue, so maybe that's
No,
something that we need to add in here that.
The
they
code
need to-
doesn't say that, and most codes don't, but most cities do add in that, do put together a template.
Well, I think anything we can add, should we not add to not leave it to interpretation?
Okay.
So you're putting the burden on the applicant to send both the mail and to make posting on the
To
property?
make posting. So what is done in most communities, you make an arrangement with a local sign company. You tell them what format is, so when somebody says, well, how am I supposed to find the property? You say, you go to so-and-so signs. They actually have a whole format already done. You buy a sign and you put it on your property.
I know, I think in Daytona Beach, I've seen in the filings that they just have a photocopy of all the mailing labels. And then that, like the oath that you sign or something saying that these were, who we sent out the notices to. And usually like a picture of the sign out there, or additional printout of it or something, is that what we would require, is that what you're?
Correct.
And would you all rather we did that?
I don't think we need to make any more work for
No, I
us,
don't think we need
for
to.
the clerk or for the city manager or for Mark.
I think, I don't know that we're gonna have that many of them. I don't know that we have that many of them. I don't know how, owners that would be on our clerk. I do feel a sense of responsibility to those in the surrounding properties, just to make sure that they have them properly noticed, because somebody could take mail and say, I put it in there, but oh my gosh, it must have fallen out in between my seat when I took it to the post office. You see what I'm saying? Is I don't know.
Yeah.
That's something that I think we need to talk about, and I would ask Don his recommendation based on, his experience and knowledge for this as well.
Again, if the applicant says they forgot the notice, the remedy is we don't go forward with your hearing, and we're gonna have to re-notify them.
But what I'm
If you find
saying,
out before the hearing.
Mhm.
but he might not acknowledge that he forgot that, and a property owner, the hearing goes forward and the property owner was never noticed. And so that's what I'm talking about is, not that anybody would ever do that, but mistakes happen, we're all human.
And a lot of times, the people that are doing the rezonings are not necessarily the owner, it's a law firm or a lawyer or something like that for them, and usually that's, I guess that's,
Yeah.
So,
property.
I really am not able to speak to whether or not this is the new common practice. I would say that you would be the only governmental entity in Putnam County handling it that way. That goes both the county, city of Palaca, city of Interlochen, I don't know about Pomona Park,
Pomona Park,
Pomona Park
right,
too.
yeah. I can weigh in on this if you guys want me to.
Okay, hold on 1 second, let Commissioner.
Okay, doing it which way? Putting the burden on the property owner? No, having the city provide the notices.
I don't know about Pomona Park, but county, city of Palaca, Interlochen, their staff handles the notices.
That is an old practice, so I'm not surprised to hear that.
So Karen, did you,
Yes, well, the past couple of, with the school department and the new zoning that's coming up, and, I noticed the, property. It's a lot easier, and we have a checklist that we go through that we have been taught, us clerks have been taught. And Pomona Park, everybody in this, in Malacca, this whole general area does it the same. So I took it upon myself, even though it wasn't in the code, to go ahead and notice the properties and, however you guys want to do it. But it's easier for me to notice them and then we charge them for the signage. That's what's been happening the past couple of months.
My only concern, and again, I've not seen it work the other way, but my concern wouldn't be with you finding out about the claim that someone wasn't properly noticed before you complete your rezoning process. My concern would be that you not find out about it until after the process has been finished. So you post the property, that's cool if you have neighbors who live there, or they're there often. But if not, and they're getting mail, notice of a rezoning, and they don't get the mail notice of the rezoning, unless it's certified mail return receipt requested, which would give you some additional security. They come back in 6 months after the zoning and say, I never got notice.
Yeah.
And now you're in a contest of, well, we can't say that you got notice. All we can say is that the applicant said you got notice. And I don't know how that works out. I mean, I don't know what kind of gyrations you go through at that point. The case law may say that if you satisfy the minimum requirements of the statute, you're all right, but if you build a provision in your code, I think you're bound to that provision. So if your code says applicant's gonna provide notice to the surrounding property owners, and it turns out that they didn't, it seems to me like somebody could challenge that rezoning, which may not be a problem unless somebody already started building something there. Then,
And like I said, the remedy in court is you redo the hearing.
well, how do you redo a hearing?
Right.
As if you can't unring a bell if they've already built a building there or started. You can redo a hearing if you want to, but are they gonna turn the zoning
It's
down?
unusual to rebuild, to unring that bell, but it can and does happen.
okay. I know whenever I got, when I first moved here and did a special, I had to do a special use permit. And, was charged a lot because, and a lot of it was
Expensive.
because of, they did all the mailings, they did the posting, they did all of that, and then they had it in their hand. I went and visited all the properties and spoke to them individually, but they actually, the city here, they did the mailings. And that gave me peace of mind knowing that had been taken care of and I didn't do anything incorrectly.
All right, well,
Yes, Commissioner DeVito.
Yeah, I was surprised to learn that this wasn't a Crescent City requirement because a few years ago, a neighbor down the street was rezoned and we got a letter. And you had to apparently notify the neighbors. But what I was going to say is, I actually own a small piece of property in Tallahassee, in an area where there are a lot of rezonings. And the notices of those come from the city. They're very well done. It says City of Tallahassee on the, return. And, it doesn't look like a piece of junk mail. So,
So I think commissioners knowing that, because it's in here multiple times throughout, and so we need to make a determination, I think, just in blanket determination, do we want to do that, or do we want to put that on the applicant?
Let me ask
Yes,
you,
okay. Yes, sir.
what is the most appropriate way to keep the city from getting in a bind? Just ask that question.
I mean,
That's what we trying to do. We trying to do things, get it out right and proper. But anything can fall through a crack.
and if the city sends out a notice, people are still gonna say that, you know, so they're gonna say it again. I mean, you guys just have to decide what you're most comfortable with. Like I said, it's much more common now that it's placed on the applicant, but, you know, I make suggestions, you make decisions, so.
Right, and no, and we appreciate that, I mean, you are trying to bring us up to current, I'm not comfortable, I personally am not comfortable with putting that on the applicant.
I'm not sure how much time you save, staff time you save in this county. Don't take this the wrong way, but your clerk is probably gonna spend a lot of time explaining to people how to send the notice out. And may spend more time doing that than she would have spent in sending the notice out. Just,
Question, Karen?
Yes.
How many notices that rezoning and annexation that we did at the school, how many letters was that? Just
One, two, we did, one for planning and zoning. We did one for planning and zoning, and then we did two for 2 readings here.
How many parcels did you
How many
send to,
actual
how
letters?
many landowners did you have to notify?
Like 10?
3, I think it was like 3 or 4.
You
On that.
probably only did the immediately adjacent.
The
Yeah.
only one that, the only,
Right, this would be a lot more.
This is 300 feet,
So
so,
like all those houses that are.
Most are
across the
300
street, you know.
city, county, they're all 300 feet in
So
Palaca.
I mean, this would be a minimum of, 5, 10, 20.
but we've noticed,
lot of
but the
parcels.
notices on the property were there the whole time,
Right,
the
that's-
whole
that's-
60 days.
I was just asking how many letters it was that you sent out.
yeah, but still, even in a
Would be-
We already have a form and a format that we use in the city to do this, correct?
Yes, I developed,
And so it's kind of streamlined,
I have a list of what I need to get, what I need to do.
and then we have a definite charge to charge people for doing this
Yep.
for them.
Yep, they get the
Okay.
board, it's all part of the advertising. Like we charge them $2,000 per fee, and then plus advertising, so they get all of that.
so is everyone in agreement?
Yeah.
We have to do, but we don't need to do a motion on this, do we need to do a motion on it?
Not necessarily, if you're in a
We're
workshop,
going through it.
by consensus, if somebody is opposed to it, they need to speak up, and then you guys figure out if you've got a consensus or not, but I would not think that you would be required to do a motion to suggest a change to a draft that isn't before your first reading anyway.
Okay,
So,
I mean,
is everybody in agreement?
Yeah,
Okay.
yeah, everything is, really.
all right,
Commissioner DeVito, are you okay? Act like
Yes,
there's
I'm-
something,
No,
you have an observation?
No, I think this is a better alternative.
Okay.
okay, so we will change that. All right, so, one of the things that the current LDC is short on are specifics in its application procedures. Again, in the last draft you saw, I think, improved upon this, but in this particular draft, we have gone a little bit further in terms of spelling out the various requirements. So annexations, LDC code amendments, abandonments and vacations, tree removal procedures. They're not new actions either in your current landowner code or last draft, but in this one, we just add a lot more detail to each of those things and more clearly define them. So another area that I want to talk about is just reflecting these character, vision, and the comp plan. We've talked about this quite a bit in the past. The current LDC was adopted, I think, 19 or 20 years ago. It was kind of a one size fits all, particularly when you're looking, or one size fits most anyway, when you're looking at the non-residential stuff. There's a lot more variation in how the current landowner code treats residential, but in terms of commercial, the big example we always use is general commercial one. So you have one solution for what goes on Central Avenue versus what happens on North Summit Street. So, these small individual lots on Central are facing the same sort of code requirements the Winn-Dixie, on the north side of town, has to meet. And both the last draft you saw and this version does address that. So, for example, the last draft you saw talked about the central business district and had overlays. We've eliminated the overlay from this draft and created just a central business zoning district that can be applied. There are some technical reasons why we proposed the overlays, but I think they were confusing for everybody. And so, we've taken those out in this particular draft.
So my question is, right now, we don't have anything that's zoned central business district.
No.
Are we going to rezone, or is it something that applicants are going to request?
We will come back with a new map, and so this gets into the technical reason why,
Creating it.
Right, no, I understand.
why I like the overlays.
The overlay.
Okay.
I mean, that's
I mean,
fine.
the overlays, the issue of the overlays was something that came from me, because typically what you'd like to do, and again, this is just mainly for the ease of getting things adopted, you really like to adopt the land development code and the zoning map at the same time in the same action. Because you spend all this time on the land development code, and oh, by the way, we've got a new map coming in. And so the overlay would allow us to have done that, because we wouldn't really be changing anybody's underlying zoning, but it confused people. So what we will do, we'll come back separately. We've, passed a map. We passed the new land development code. Here's the map. It will require some comp plan amendment changes because we're not using the overlays now. But basically, the map is going to be the existing map with some changes to the central business district. So most people are not going to be affected by the map when we bring it forward. And we're going to bring forward that map. We'll give people an opportunity to know what's going on and notice it's not going to get tied up in a discussion of the bigger land development code. If somebody wants to opt out, we'll let them opt out. I hope they don't. I'd like to have very nice, clean central business district zoning along central business district. But if somebody decides, hey, I have this property, I don't really trust government, they can opt out of it, and then later on, if they find that, they want to do something on their property, or they have a buyer that comes along and it's easier for them, and they find out it's easier to do something in the central business district, they'll be able to apply.
So if we did an overlay, would they be able to still opt out?
Yeah, because the overlay you opt into, correct?
Yeah, well, you do want to give an opportunity, Renee, but the overlay it's not a new zoning category, so to speak. It's just something that gets dropped in over their current zoning.
And it's new requirement, new.
So, but, like I said, I think this approach that we're taking might be, it might take 2 steps, but it'll be a lot less confusing.
But you understand why we're trying to establish this commercial district, this commercial district.
Correct,
And
and
so,
the land development code has a district, and we will come back in and we will apply that to Central Avenue.
So I'm sorry, I'm,
Yeah,
don't understand.
Yeah, I'm a little bit lost, but.
No, I just, so you said that the property owner could opt out of what?
We're gonna come in and with a map that is gonna rezone, people currently have
All right, I got that.
GC1, right?
So you're saying they can opt out of your current map, or your new map?
The new map,
Yes.
yes.
well, every
Yeah.
owner pretty much is gonna
We don't want people to opt out.
using their place for.
I know you
storage.
don't,
I
but my
don't-
question is, isn't that gonna create its own problem where you've got people trying to decide whether they opt out or not, and they don't,
Well,
you said they don't trust the government, so they opt out, what if half of them opt out and half of them don't, and you really haven't created your zoning, your new category.
But it would, to forcibly change somebody's zoning against, when they say, I don't want it to be changed, that'd be a bigger problem.
Right.
They say, I want GC1, don't change me to CBD.
It's common practice when you do these mass rezonings to give people an opportunity to opt out. We just did a 34,000 acre rezoning in Linnell. We spent 2 years coming up with this, with the comp plan amendments and rezoning. Of those 34,000 acres, 2,000 people decided to drop out.
Okay, Commissioner Banks has a question, and I'll get to you at the.
Lakeview. Norfolk Town, here, Red Cross from our room, wherever you want. Now, get those people out,
Of the CRA.
CRA.
Okay, same thing happened down here, and it's confusing down here on the south end, because some are and some aren't.
And when we approach them and say, we want to create a central business district, it'll actually give you more rights to do more with your property, but if you don't want to participate, it'll be free now to change your zoning. You can always come back and ask for a rezoning later, but what is it for rezoning, $2,000? So it'll cost you in the future. And we'll explain, this is the rights you have under GC1, these are the rights you have under CBD. And so we'd like to rezone this.
There's got to be an easier way to, there's got to be a better way to do
The
this.
home is like,
Yeah, because right now, I think
residents, people, on Central Avenue live there.
Yeah.
Commissioner.
Commissioner DeVito?
Yes, so I'm not clear on this. So Mark just said, what I've been thinking, we've been working on this for about 2 years. And the last I heard, I mean, we've had a number of workshops, public workshops, and we went over everything in detail. The last I heard, we were going to have a downtown overlay district. Was that not correct?
That's the central district.
Well, we'd have both, we'd have a CBD and a broader overlay.
Okay, but I'm saying that this central business district zoning is new to us with this addition. Okay, so
It's
hold on.
essentially the requirements of the overlay.
Okay, it's the
It's not
requirements
significantly different, it's just whether it's a
Okay.
zoning category or an overlay.
But it is different because it's a zoning category. So for example, the parking changes that were going to be allowed in the overlay. If someone opts out, what does that do to the parking changes?
They don't get them.
Yeah,
Again,
I'll have staff answer, please.
Yeah, they don't get them. So if later on they have a buyer who comes in, because that's how this normally ends up, you fill it in. What happens is somebody decides, they just don't trust the changes. And obviously we will spend as much time as it takes to explain these to the interested party owners. There's not that many.
I was gonna ask, how many people are we talking about? How many property owners?
I don't know off the top of my head right now, but we're 15.
15?
Yeah, that's a guess.
Yeah,
It's probably
Well,
manageable.
Just central.
yeah, so I think that'll be
But what
manageable.
happens is all 15 opt out? What have we really done?
We have it in place. And this is not, the CBD is not a new, that's from day one of the draft. It was called DR1 in the beginning, downtown retail. And we changed it to central business district. And the overlay had those rights in a larger area. We kept getting questions like, why, we don't want the downtown to get that big and expand. Why would we do that? Why would we allow those rights further out? So we finally just said, let's forget about the overlay. It's not clear in anybody's mind. Let's go back to the downtown zoning. Instead of DR1, it's CBD, which has all the rights, which means we share parking and there's all the issues, mixed use, all that stuff. That's been there since the very first draft, and Lupita was working on that.
Yeah.
That's not new. Just the overlay was really confusing people, like, why would we want parking exemptions way out in these neighborhoods? So we finally said, let's forget about the overlay, let's just focus on, and if, on day one, no one wants in, everybody's like, no, you're taking away my rights. You're down zoning me, we can't convince them that we're not down zoning you.
Yeah.
It'll still be in place, so in the future, if somebody says, I want to do a project, I'd like that CBD zoning, we'll say, absolutely. And we have a map of where we want that CBD zoning.
Just so you know, the land development code wouldn't prohibit, if you decide you want to rezone all these people, you can. This opt-out is not in the land development code. But what I'm saying, my suggestion was, if you wanted to allow people to opt out,
So they don't sue us for a taking.
so they can, depending on, I think that would be difficult because we're not diminishing the right people, but Like I
Commissioner
said-
Lori has a question. Hold on. Yeah, Commissioner
Wouldn't
Lori,
it be
please.
easier just to do a downtown overlay and then let people opt into it to get the benefits?
Well,
Because then we're not forcing anyone to change their zoning. If they want to change it, they can take advantage of the options. The problem you're saying is that the downtown overlay was bigger than downtown, or even bigger than Central. Why don't we just put it in place for the 2 blocks on each side of Central Avenue and let people opt in to get the benefits instead of forcing zoning down people's throats? That just seems,
well, I'm not suggesting maybe force zoning on
but you
anybody.
are, if you're saying that we're gonna rezone them, and if they want to opt out, they can.
No, he didn't say they would rezone them. He just said that it would be rezoned and they could opt in and they could opt out.
If I understand you correctly, you're gonna,
Rather you give them choice, yeah.
so if help me understanding, and I apologize, I missed all the prior workshops, and
That's
maybe I missed some prefacing information that would have helped, but, so you're saying that you're gonna adopt a new zoning map, is that correct? And the new zoning map is gonna include these properties in the downtown business district. It'll be included in that map under a downtown zoning district, downtown business district
Yeah,
category.
central business, but yes.
Center. But you're not going to impose the, actually, the characteristics or rules of the downtown business district or central business district on the property owners unless they opt in.
Well, here's what I'm saying. We're gonna say we're gonna rezone your property. When we publish this map, vast majority of the city is not gonna see any changes whatsoever, but some properties will. And then when we get people who, we're gonna get a lot of people who are gonna just wanna know more about it. We're gonna get a lot of people who are just going to be a little suspicious of it. And then we will spend some time trying to explain to them the benefits of that. But if somebody just really wants to opt out,
You're gonna say this isn't gonna apply to you.
That's
we'll
all.
just say, you just give me this, just give me something where you said you don't want this. When we bring it forward to the commission, we'll say, we're rezoning all of these parcels. The owners of parcels, 1, 2, and 3 said they didn't want to be.
All right, so how about your comprehensive plan? Does your comprehensive plan,
No, this will be consistent because it'll be a commercial, it'll be one of the categories that will be.
so either one will be consistent with your
So either one
comp,
will be
whether they
consistent.
opt in or out, they'll be consistent with the comp plan.
Correct.
And your uses, your adjacent uses of the one district are not such so that they're gonna be offensive to property that's remains in the old district or vice versa?
Yeah.
And you only got about 15 properties. So basically, you're gonna publish intent to rezone all the properties.
Right.
If nobody shows up and cares, it's gonna get rezoned. The properties will get rezoned. If somebody shows up and says, I don't want this, whole bunch of somebody's, 2 somebody's, whatever, then if you can't convince them that it's good for them to stay in, you're gonna take them out. Right?
Just those 2.
Right.
Yeah.
Yeah, you're not gonna get just 2. Commissioner DeVito.
Okay, so what I'm finding interesting here is, Mark, you're saying we're going to rezone. You're talking like you're gonna do it. The city rezones, right?
Well, when I
So-
say we're gonna rezone, I'm talking collectively. I'm gonna bring forward a map and yes, I make suggestions, you make decisions.
Okay, but it sounds like we don't have anything to do with this.
No, I didn't get that. He's our staff, so he would
I
bring
know
it forward.
he's our staff, but don't we have to have a proposal from staff and we initiate a rezoning?
I think his proposal was that we
Okay.
would do a rezoning, and so that would be up to us.
Central
Yes.
business district.
Okay, what I'm talking about is there are people potentially listening right now or listening to the tape later. And when I hear Mark, it sounds like this is something that Zev Cohen is just going to come up with. And but that might.
I never got that, but that's okay.
Okay,
Thank you for
but-
clarifying. Thank you
Yeah,
for
that's what I'm
clarifying.
saying, but also, I think what we need to be cognizant of, and I don't know how much this was brought forward before, but we are, once we adopt this code, we are still only 50% or less there as far as downtown goes, right? I mean, there's a substantial amount of work to be done after, Okay, after we adopt this code, we have more work to do to get the changes we want downtown. The changes we want don't really come until we rezone.
Correct, the second step.
Okay, and I mean, I may be counting wrong, but when I looked up the historic buildings on Central Avenue, I think I came up with a lot more than 15.
There's about 38 parcels, just counting right past that front.
That was-
So
I said I didn't know Charles threw up the number 15. I mean,
Well,
if you would like us to bring forward a new zoning map when we bring this to first reading, I mean, we can do it all at the same time.
I think more, I think what, this is my concern, especially with what you've just shared. We had enough of an issue when we were trying to do our comp plan amendments, our updates, just because people found out in the future land use map that they were multifamily and they were residential, and it created a tremendous amount of angst, confusion, thought we were lack of transparency on our part, and we had to, I mean, we thought, all of us sat here and we all know, except for Commissioner Lloyd, I think you sat out there when we were doing that, what we had to go through with that and the general public, and how helping them to understand. And so it's easy to say it, this is what we're gonna do, but when you go down that path, it's a much more difficult process with the property owners. You're a planner, you understand it, you know exactly what you're talking about, you know the effect will really not be, actually it will be to their benefit. It's convincing them it's to their benefit. And so that's I think what you're hearing here from, I'm hearing from the commission, that's how I feel, is that, is what we're doing, going to create more of a problem for us than not.
That's why we said, we'll have a provision you can opt out, because when you adopt the code, and I said this from the very beginning, the CBD, Central Business District, it'll create it on paper in the code, it won't exist in our zoning, there won't be any property zone CBD. We have to take that step, so one way, we just leave it and let people know about it, and see if they come in one at a time and they wanna switch over and we can offer it for free. Another way is say, look, this whole area, we're gonna switch everybody who wants to switch. Anybody wants out, we're gonna have public workshops, we're gonna explain it over and over and over again. Here's your list of rights as GC1, here's your list of rights as CBD. We wanna switch all this and create a central business district that has mixed use and all these benefits. And then we finally get through it all, we have a list of people who said yes, said no, and you vote, and we change them. And people are out, they'll sit and watch, and then over time, they may come back, well, I'd like to change too, or they may just sit with it and say the GC1.
Well, and I get all that, but I think what's gonna end up happening is, again, they're not gonna understand it, and the people that were multifamily, they would have opted out of our amendment, and so I think what you're gonna have is a mismatch of properties up and down Central Avenue. So what can we do to where we don't have that? And then you're not gonna be here, we're not here forever. You know, anything can happen, and somebody else is gonna have to come in and try to figure out exactly what is what out there on those properties.
Unfortunately, the only way to, determine what's gonna happen and make it all the same would be for the city to buy it all, and then we can do what we want with it. You know, if you have individual owners, they're gonna do what they are gonna do.
I don't
I
think
think
that.
we'll do some meetings, we'll meet with people. Like I said, I just went through, it literally was 34,000 acres in Benel. The very first meeting was 300 very angry property owners. When we adopted it, less than 4 people showed up. Because we answered all their questions, and we did have a handful of people who opted out, and they were happy to go along their way.
Mark, that's, we're talking about here in Crescent City, not 34,000
We
acres.
have been fighting for
Same
4 years, everything that we do here, we have fought for 4 years, everything we do here, and so it's whether or not the commission is ready for another fight, and
But you-
I'm
but
just
you
being
know-
honest about it.
Not to interject where I shouldn't, but it's gonna be hard for people to complain too much when you tell them you can opt out. All you have to do is say you don't want it. Now, then your biggest risk is what I think you mentioned, and that is that you've got mixed zoning along that area. That would be your biggest risk. But a lot depends upon the sales job that you do. And when I say sales job, I'm not talking about inappropriate or misleading. I'm just saying education, an educational program and outreach that you make. Because, you know, I agree with what you're saying. You, when the city of Blacko did it some years ago, you know, we created downtown business, riverfront business, and then on and on. And there wasn't an opt-out provision, and we just had hearings, resolved. And there weren't no lawsuits. I mean, there are always going to be people who are not happy, and that reflects back to you guys. I get that. But there wasn't an opt-out provision. In your scenario, you have an opt-out provision, and if your lead in your discussion is, before you say anything, understand this, if you don't want to be included, you don't have to be. But just give us the privilege of letting us show why it would benefit you to be included, and go. How can they be mad at you for telling them you're going to try to improve the district, but if they don't want to be part of it, they don't have to be? I mean, that would seem like, I understand the logic of what you're saying, Mark. I just shut up.
I get that. I still think that we're creating a can of worms because we've got people opted in and opted out.
But I think we're always gonna have that can.
We always.
Not if we have.
And, you know, they'll just have the current zoning they've had for years.
If you want it.
You know?
We can always-
So, that's what I'm saying, we're not rezoning anyone and giving them, if we put the overlay back, just the 2 blocks around Central, if you want the benefits of the parking bonus and ability to share parking and 0 lot lines, then you opt in, because you're gonna build a building there or something like that, opt into the downtown overlay, and there you go. So instead of us changing it all, and then letting people not do it, why don't we just let people do it if they wanna do it? That's what I was getting at. I don't know, it just seems like.
Yeah, either way, it doesn't have to be an overlay or anything. None of what we're talking about actually has anything to do with the way the land is structured. You could decide, hey, we don't want to change the map. We've created a new zoning district. If people want it, they can come in and ask for it. Or you can decide you could go forward in future, we're gonna rezone it and there's no opt-outs. Or you could go forward and say, we'll let people opt out. You know,
Well, let me ask you this, what can we do to have less complaints and do it effectively and efficiently? What can we do? That's what this body should be looking into. What can we do to keep from buying us stuff? Because for years and years, I've been hearing some of the same stuff, but I'm hearing now. I really have. Because we got part of the town right now, but I know that that's another setting, from the town. But we got part of that town, that all the people came in here that particular night. We don't want to down Lakeview. But it was on a different setting, it wasn't on this setting. But what can we do? How can we put it, how can we phrase it into our paperwork so we are having?
yeah, I don't think this is not a paperwork thing. Like I said, this is land development, the language is for you.
You do away with central business.
But I'm just mentioning this stuff. I was just thinking about future, how we might
Right,
go about adopting it.
right.
And so we're not really talking about anything that's in the land of right now. There's a district that's called Central Business District. It could be, you guys could apply it, people could apply for it. So the answer to your question is A, you're not gonna eliminate all the questions, but the answer is going out and spending a little bit of time talking to people and selling it to them, the same way the master plan was done.
Passing the code will just establish the district, won't implement.
Right.
You can decide in the future how we want to ease in to a CBD. One of the reasons we're looking at the code was to create a central business district.
Well, because
It's kind of fundamental to why we move forward.
the buildings were kind of like that before we had mixed use in central business district. We had zero lot lines, you had verandas that have under the sidewalk, and all of those things are things that this central business district allows, but GC1 is not, correct?
At some point, it all got painted GC1.
Because that's the only zoning district we have basically in this.
Yeah.
I have had conversations with people who have been looking at, who either own property or looking at property. They've described the combination of things to me that can't be done under the current GC1, but I have told, oh, by the way, you know, we're having this conversation at a time, we actually kind of know what's gonna be put forward. And all those conversations have been positive. You know, because it gives them an opportunity, for example, you know, talking to a landowner who wants to be able to have a property that will let them do some type of office use, like a professional office in Central Avenue, but also would like to retain the ability at some point in the future to do bed and breakfast. Well, under the current landlord code, that's not a possibility. There are two different types of zoning category. Under the new central business district, you would have that option. You could put an office in. You know, by the way, if that office doesn't work out in 2 years, they move out, and you want to turn this into a bed and breakfast, you'll be able to do that under the new land development code. It's like, well, okay, well, when is that gonna happen? Well, we gotta go through a process. We gotta get the new land development code in place, and then we're gonna come through zoning. So all the conversations that I've had with people, and I talk to people all the time, because if a piece of property is, somebody is buying, if a piece of property is up for sale, you know, I'll usually get 7 or 8 phone calls from different people who are looking at buying it, and there are different scenarios for it, and, you know, so I do get to talk to them.
They want to know what they can do.
Right.
So that's the reason why.
Mayor, I have 2 questions, or a question and a comment. One, with this issue with downtown, which is about 7 blocks on Central Avenue, if someone wants to do something that is not allowed in the GC1 code now, would we currently be able to give them a variance for some of that?
You know, you can't give a use variance.
Okay.
Law, you can give a variance to dimensional requirements,
Right.
but you can't do a use variance.
We would have to rezone it. Correct. Okay, so and then I have a comment. My comment is, this is all very helpful information to us. It would be helpful to get that kind of feedback in the monthly city manager's report, or just a report from planning and zoning, because otherwise we are not necessarily going to know what prospective buyers want or looking for. You are on the first line of that. So for me, I don't know about the rest of the commission, but I would find that very helpful information to know the kind of inquiries that we are getting, or the concerns that property owners
Well,
are
I
having.
put a version, I don't go into a lot of
I mean,
detail.
I'm not saying for a particular property, but when inquiries are made or our code is not accommodating what potential buyers want, just in general, I think that's very helpful to know.
Okay. Well, we've got to figure out what we're gonna do with this. And so, commissioners,
Mayor,
yes.
I mean,
Commissioner
my feeling is that I like the idea of central business district. Let's put it in the code, let's have it, we can talk about what we're gonna do with it later, because that's really what we need to do. We're not deciding right now whether we're rezoning all of downtown or what right now, correct?
Yes.
Right.
Let's create it, we've agreed on the
It makes
features
sense.
of it, it makes sense, let's do that, and let's move on.
Yeah.
And we can, later on, we can maybe put a, like, 1 year, anyone wants to opt in, do it now, blah, 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 something like that. But like I'm saying, that's not what we're discussing right now anyway, it's not the land development code.
That was
What we're
something
doing.
I was thinking too, that as they change hands, as properties change hands, and Don, this is a question too, that if we didn't do that, if we put it in here, that as a property changes hands, could that be the requirement, that they have to adhere to that new?
Yes, I think you could put it in there. You're almost making it a conditional use that doesn't run with the land. I mean, that's kind of a different terminology for it. If you said that you can opt out now, but if you sell, your opt-out goes away. Problem then is, I don't know how property owners are gonna feel about the fact that if they try to market their property, they're gonna have to market with the caveat that, and the disclaimer that you can't rely upon the existing zoning, you'll be subject to a new zoning if you buy. I think that would probably have some chilling effect on your selling your property. It would be easier for property owners. Normally zoning runs with the land.
Yeah.
So does a conditional use or special exception, depending upon how your code describes it. It's rare that you can tailor a conditional use to the property owner that applies for it. That's rare, because the law presumes that if it's good for the land, it's good for the land, regardless of who owns it. So from my perspective, I would think that would be a complication that probably would not be welcome, to say that this is gonna be, you can opt out, but when you sell, you lose that opt-out option, and the new buyer comes in under the new code. I believe that.
Yeah,
My understanding,
I've never seen that. That doesn't.
I was just asking if that could, my understanding is the whole reason we're really looking at this, especially down Central Avenue, is we have buildings that are sitting there that are just sitting there. And we want those buildings occupied, we want activity going on in those buildings. And so whatever we do, it's how do we encourage that to happen? And, I don't know, just to,
You know, a lot of times when someone's gonna buy a property to build something, they're gonna apply for zoning changes first, and then they sell, and then have a contract with the current owner. They're gonna get the zoning, apply for the zoning, get the zoning if it's approved, and then buy it. So if we have that option, they can apply for the CBD, get approved by the land, right?
Yeah.
I think that, you know, quite frankly, many years ago when they zoned it the way it is now, that was the mistake.
Or we just
You know,
can't-
and now kind of trying to get it back to where I think it was at one time, it's just gonna be a little difficult. But we'll
If
get
we have the option, then this option exists.
we'll get there.
Now, are we going to limit the area that this zoning can be, or the zoning category can apply to somewhere? I mean, I don't see that in here. Is that
Well,
two blocks?
we'll bring forward a map.
Yeah.
You know, you guys have seen the version of it. It hasn't changed since the last time you saw it.
No.
And I can bring it up, but really that's not what, I was really mentioning a step that comes forward basically for information. And I understand that you guys
you
got
triggered.
very interested
Oh,
in
I mean,
that.
Let me say this so we can move on.
And I promised Karen before the meeting that, you know, I was gonna try to say things as part of my presentation, and I was not going to say things that would create more questions than I answered.
Lie down the box.
And I am, Karen, I completely failed, I'm sorry.
Commissioner Banks has something to say, Commissioner DeVito, and then I'll refer to you.
But you know, the mayor brought this out not so long ago, talking. Once upon a time, on the commission, when we first established, we had a lot of elderly commissioners. They wanted this to be a travel bed and ease city. That's why you see so many situations that we are trying to change now, been like that for years. And you're gonna have a turnover of commissioners. There's no way around it. You're gonna have a turnover, and you might have a turnover of younger people, and they want to see the town blossom. Then you're gonna get a grandfathers, that means cute with me. Grandfathers that want the town to stay like it is. So that's the problem you run in with the little small. I know you run into it quite a bit of town. But see, the commission up here now, we want progress, we want change, so we want to fix it so when it is a piece of land that can bless our town, that we can sell on a certain code, we'll be able to do it. I think that's all the commissions are trying to care folks now. You know, you just like commissioner said this while ago. We just discussing it now, and be some language added in there in the future, but right now, it's time to move on.
Yeah.
Okay, Commissioner Vito?
Yeah, my concern is, Mark, it's not that you don't say something that causes us to ask questions. My concern is, we're being asked to pass this as an ordinance. You have a cover memo. I had questions on here. I was gonna ask the mayor if I could ask my questions about the cover memo before we started. Because you give a general description of a number of changes that have been made since we last had our workshops on this. But there's no strike-throughs, there's no specific list of what's been changed. So, you're going to have us ask questions. The mayor's already asked a question about the notice requirements. So, if this is my fellow commissioner, if we're adopting this as an ordinance and mark this to you, we're responsible to know what's in it. So we can tell people what we're passing. This affects all of our lives. So it's not what you say necessarily, it's maybe what you don't say or what's not written. So anyway, we're going to have questions about ordinances, that's the bottom line.
Understood. And I haven't gotten through the changes that I wanted to highlight. We just.
Okay, go ahead. Let's go ahead, let's continue.
Let's take Commissioner Banks' advice and let's move on.
Karen, I think some of the commissioners are a little, are you full?
No,
Oh, okay, you're
No,
full.
I think I'll-
if you guys are cool, I'm.
You want mine? Here, I have grab that to her.
But, and Mayor,
Yes.
You know, you get cold.
I know, I will, I'll grab it back. Don't they, don't hesitate to grab it back, yes, Commissioner Vito.
I need a brief 5-minute break, if that is possible.
Okay, we'll do a 5-minute break. Recess for 5 minutes.
Mark, every time you come, you just got problems.
I know.
That's it.
Okay.
Mark, you're up.
Sorry.
That's okay. Do you need to finish?
No.
Okay.
Okay, so we talked about the overlays. So, one of the deficiencies, and, you know, we talked about the GC1 and how, that didn't necessarily reflect the character. We have created several new zoning districts. These are all in the draft, the last draft you saw, but I wanted to highlight them. So, you know, one of the things with the current land development code, it's just not very well matched to the comp plan. So with and this caused some of this issue with the multifamily, they all had SR1. So there isn't a really good match in the current land development code between some of the zoning districts and the future land use element. So we have created additional single-family residential, a new multifamily, new mixed use that will just better align with the densities that are allowed in the comp plan. So for example, the SR1 and the SR2, if you actually look at the density per acre, they don't match up with the density that's allowed in the low density residential. You could actually do a denser development if somebody's not looking at the comp plan at the same time. So these additional categories will just make that easier. You can apply for a category that is a much closer match to the future land use. Accessory uses. The current land development code has very limited information about accessory types of allowed accessory uses. So it talks about some additional, you know, there's a lot of detail about garage apartments, which nobody's asked me about a garage apartment since I've been involved with Crescent City. But I've been asked about all sorts of other accessories, none of which, there's not a lot of guidance in the current land development code about those accessory type structures. So both the draft and this document, you know, extensively add to that. And so there is language about accessory dwelling units, there's information about outdoor storage, there's information about, you know, drive-throughs associated with a restaurant. You know, there wasn't anything about communication towers, so all that is in your prior draft, it's in this version as well. Variances in site plan. The current LDC, the variance procedures were actually kind of very hard to find in the current land development code, because normally you would look for a section that says, you know, site plan approval or subdivision of variances. There is not a section entitled variances in the current land development code. And the very first time I had to deal with this, it actually took me a very long time to find that the variances are actually buried in the powers and duties of the Planning and Zoning Commission. And so that's where you then actually find with the variance procedure criteria. So that was it's.
So where is it now?
So
In this draft?
it's in Article 2, and I'll talk a little bit about that more. Okay, so so we put it in Article 2 with a number of other provisions. So, but I wanted to talk about variances because there was only one type of variance in the existing land development code. This particular the draft allows for both what we consider a normal type variance and an administrative variance. So this does give the ability for the DRC to issue what we would consider minor variances, which would be a 10% reduction in parking and variances to dimensions that are less than 1 foot. So somebody doesn't have to go through a variance process. Usually where this comes up is, and this is why I lumped it in variances, site plan. Usually this comes up as part of the site plan process, it comes up with construction. So what happens is somebody out in the field has constructed something and it's a small encroachment in the setback. Again, this issue of, what do you do about a building that has been constructed? So the process to make that legal is to go through variances. So this would give, staff the ability, what truly happens out in the field in most communities. One, some communities make people go through variance requests. Other communities CO those buildings. This is, with encroachments and setbacks, it happens all the time. And so the other thing, and again, this is related, the DRC does have the ability to approve minor site plans as well. Site plans that involve additions of less than 25,000 square feet to an existing.
2,500.
2,500, sorry. I think the original draft had a much larger number in it, which was a typo. It's 2,500, and I just repeated the typo. I was reading it. And the other thing is, it'll allow things for like parking lot reconfigure. Obviously, somebody can restripe a parking lot, but every now and then, I've had conversations with people here in town, they actually want to reconfigure the parking lot. And the process for that now currently in the land development code is, well, you gotta go to planning, you gotta do a full site plan, you gotta go to the planning and zoning commission, and they can approve, a reconfiguration of your parking lot. We've also had people who've had wanted to add landscaping. Technically, you have to follow your landscape plan, and if you're adding landscaping here, this is not on your landscape plan, that's an amendment to to your landscape plan. And that is a visit so staff's in a position to either letting, just go ahead and add stuff or let people do it. So that stuff is now in your, is in this version of land development code. Trees, and we talked about this a little bit before the meeting. The current LBC tree protection, I think is kind of confusing and left out a number of different details. The last version that you saw and this version, addresses tree protection much more comprehensively. We have moved away from the nomenclature of heritage tree to specimen trees and historic trees. There's a lot of information in there about how those are addressed and how they're affected on site. All of that was in the prior drafts. We did clean it up a little bit in the sense that there were just some of the tables needed to have some corrections. But in this version, what we did do is we synced up there are exemptions, we synced up the exemptions that are allowed in the state law for owner-occupied property. That wasn't recognized. It's certainly not recognized in your current land development code, and it wasn't recognized in our draft. But there is state law that lets owner-occupied property, basically, they don't have to get permits to take down trees. And so we've synced that up, as long as it's not.
Wait a second, make sure, because I hear some moaning over here, so
Yeah.
make sure that you clarify that it's the 36 inches or however much, if it's a native tree, there still are some certain requirements.
Oh, yeah, there's protections, but
Yeah.
the,
That's in here.
the state legislature did preempt, for owner-occupied property, they preempted the requirement. Now the owner of the property still has to have documentation that they've had an arborist come out and that there was something, divers, they can't just themselves go out and say, I want to take down the streets. Looks to me like it's disease, they have to have some documentation. But they don't, this is something that was done in Tallahassee, they don't have, if they have somebody come an arborist or a landscape architect, they don't have to come get a permit. This is owner occupied property only. This isn't developers. We did take out but if it's part of a tree requirement, we have eliminated that. The other thing is, in this current version of the code, we have put in penalties for the removal of trees without permits. And so that is $25 per cross-sectional inch, okay, which is radius squared times 5. So $25 per,
The diameter.
crossing, but no, we're not we're taking the radius, we're squaring it, okay, and then we're multiplying by pi, charging $25. So if you were to take down an 18, so if you were to take down an 18-inch
It's the
tree
surface area.
without a permit, so that have a radius of, 9, be about $2,000 would be the penalty for that one tree.
Are you talking on private property?
Yes,
So in other words, if I have an 18-inch tree and I want it gone, and I just chop it down, you can charge me $2,000 because I didn't get a permit?
owner occupied is totally different. Okay, but a land developer comes in and clears the site without having gone through site plan approval and give us, like the Moonshine Acres guy down there, those are the people who would end up being paying this fine.
So it's the radius squared, so you're doing.
Radius, it's cross-sectional square inch.
Yeah, okay, that's what I meant, square inch, so you're looking
Yeah.
at the actual surface area.
Yeah.
Times 25, okay.
And that's any tree?
No, anything that meets the definition of a tree. It would be one of
How's tree defined?
It's kind of near the.
You know.
So does not include invasive species?
No, it doesn't include invasive trees, it doesn't include
Invasive species are
diseased or
required.
designed trees.
Yeah.
It's just, it's really designed to be a deterrent.
Believe me, I'm okay taking trees out.
Yeah.
We have, you should.
Okay, and then, yeah, another question. Okay, if I buy 200, acres of land, well, not 200, that's 50 acres of land in a municipality, and they got some of these heritage trees on them, and I wanna put bulldozer on them, I'm gonna have to pay, and I'm the property owner.
If you just go out, if this is commercial property, or let's say you bought it, put it in a subdivision, but you decided you want to start clearing before you've gone through the process, right? The way the land development code works is when you go through the site plan approval process, you identify the trees you're saving, you identify the trees that you're gonna take out, and you mitigate for that. So there's a plan where you would put together some sort of replacement trees. And we show that on the site plan, it would get reviewed by the DRC, and then it go to the planning and zoning commission, and depending upon what the type of development is, it might come before you guys if it's a subdivision. But if they decided that they didn't want to go through all that process and remove some trees ahead of time, then they pay penalties.
Yes. Okay, so somewhere in here, it looks as if you don't have to go approval, you can completely clear a residential lot that's less than 7,500 square feet.
Yeah, single family lots,
Yeah. I'm talking about subdivisions, single-family lots. Are a little bit.
No, I'm talking about single family lot.
So somebody comes in and they buy a lot and they're gonna build on it, one lot,
When you say,
not a developer, but
But
a
somewhere in here, it says lots less than 7,500 square feet, which is, I don't know, that's somewhere, that's a little bigger than 5,500. That it can just be clear.
okay, let's see.
It's over on page 115. So it's the building permit application, lots less than 7,500 square feet, 100% of the lot may be cleared of non-historic trees. It's non-historic trees. Lots between 7,500 and 10,000 square feet, 75% of the lot may be cleared of non-historic trees.
Yes.
And I wanted to go back to that, you were saying that we changed the terminology to historic instead of heritage. Is that,
Specimen in historic.
I mean,
Why?
why? I mean, that's what I'm sure.
I mean, it's just, it's more, it's a more common usage in
our tree ordinance specifies those two definitions, so we have to readopt the tree ordinance.
Well, this essentially becomes your tree protection
Yeah, 'cause
ordinance.
this has the tree ordinance, the tree ordinance.
So
It
this,
identifies those, yes.
Mayor, this is my question and that I could never get an answer to. As we went through this process, I asked, could Zeb Cohen please identify what we are repealing with this code that we're adopting?
You're gonna
Wait a minute.
repeal your entire land development code.
Okay, plus, but we are adding in some ordinances that are not currently part of the land development code. And it appears to me that we are repealing our entire tree ordinance, and which will no longer be in our ordinances, it will be in our huge land development code. And we're also repealing the provision that relates to waterways. I mean, I wanted to.
Waterways gets added, there's a portion of your land of code that has waterways, that's untouched. There's a portion though that did not get codified. That portion that did not get codified is at the end of this, right? So
Okay.
you already have waterways. If you were to go on Muni Code right now and look at waterways,
Yeah,
there's what you had previously for waterways that deals with how you deal with boats and that sort of stuff. The portion that kind of deals with more the treatment of land and not, you know, that's in here. And that was driven, normally we don't have a waterways section of land development code. The stuff that we included in here is the stuff that Unicode told us they would like us to have it in the land development code, not in,
A separate
Code of
ordinance.
ordinances.
yeah.
okay, but no, so far, this is the first time anyone's identified that for us. So you were saying, basically, we're repealing our existing tree ordinance, and this will replace it.
You're repealing the portions that you have you have two tree ordinances in two different places, right? One's in the code
Yes.
of ordinances, one's in your land development code. The
Right.
portion that's in the land development code is gonna be repealed along with the rest of the land development code.
Okay, so what happens to 18.5.5?
Because they won't match if you're using different terminology.
I mean, we can change the terminology, I mean,
No, I mean, I think we need to be very clear on what we're doing. It looks as if portions of existing 18.5.5 have been changed and moved to the land development code. There's portions regarding trees in the land development code as it exists today that I don't see in this new version. So.
right, so anything that you don't see, all right, that this only affects things that are in direct conflict,
I'm sorry, direct conflict with what?
this new ordinance, right? If it's in, you know,
Okay,
when you read all these ordinances that come before you, if you read the fine print in every ordinance you've probably ever approved,
yeah.
there's language in there, in one of those paragraphs at the bottom, anything in conflict herewith is repealed.
Okay.
If there's not a conflict, it doesn't get repealed.
Okay, but for commission, this is why I'm asking, because this is 200 pages of ordinance, and if we adopt this and we don't know ahead of time what is in conflict, and there's a little tag thing at the end that says anything in conflict is repealed, we have no idea what we're repealing.
Well, I think what we're
Really
also
don't.
doing though, by accepting this, is we're saying this is what we want to be our new rules. These are our new rules.
But
Regardless of what we had in the past, this is our new rules.
But what Mark is saying is that there will be some things in our current code of ordinances that will be blanket repealed, but they are not identified anywhere for
No.
us or for
I
the
didn't
public.
hear you say that.
That's not necessarily what I've said. First of all, what I've said, anything in your current land development code, that goes away,
Yes,
right?
That goes
Yeah.
away. Exactly, these are the new land.
right,
So the portion, like, this came up in the conversation with the waterway, there's a portion of your waterway that this doesn't address. And so, I mean, you did indicate, if you guys have a preference, if you'd like the specimen trees to be called heritage trees, you know, we can call them heritage trees.
What, I think what, and we talked about, I talked to you a little bit about this before the meeting, is in standard practice, so if we get developers in here, just so that we have something a little more uniform, so they come here and they understand what we're talking about, how do they refer to a tree? I mean, if it all means the same tree, how do they typically refer?
Specimen versus heritage is more widely used in the industry than heritage. Heritage does seem to be something that's used more commonly in Putnam County, but it's not in much of the rest of the state. And it varies, they don't do the same, but if you're gonna ask me, what do most places use? Specimen in his heritage, first of all, I know a developer coming to your town is never going to look in your code of ordinances to find out what your tree requirements are.
Here, there's definitions of heritage, there's definitions for champion trees. Most generally, those are trees in the forest, Some of our trees here are very big, they would be considered heritage trees because of their size. And that's how they figure it out, is with dimensions. And here in Crescent City, anything that has these dimensions, whether it's a nuisance tree or not, becomes a heritage tree, which really shouldn't be. Okay, so it really has to, there's more definition to trees than the way we kind of do it here in Crescent City. So, in the same way, you're just kind of generalizing what you're saying. I agree, I think we're kind of killing this to death and we don't need to.
Oh, we need to.
I just,
We need to know what we
Kind of.
have.
I'm kind of with Commissioner DeVito on this, so why, are we just gonna dump 18.5 from our code of ordinance, or, from Unicode, from our code of ordinances? Because that's where that's the tree ordinance, correct?
Yes.
And also we have the historic preservation ordinance. If this is going to supplant and repeal that? Because you have a lot of stuff in here that it's not actually included in our historic preservation ordinance, but you're including in here, like certificates for appropriateness stuff, which I'm fine with, but I'm just trying to.
Yes,
Are we creating these things now and so we need to have Unicode take all that stuff out of our code of ordinances? Because there's gonna be a conflict here. The LDC is new,
When
and if you're saying it's about a repeal,
When you adopt this ordinance, as you adopt any of you, this happens with every single one of the ordinances you ever adopt.
I understand, but so explain to me
You
what.
repealed
the
anything
process
that's
is.
in conflict with.
Right, does that mean that someone is actually, Unicode's gonna go through and take it all out of our code of ordinances?
Yeah, we're gonna go back and forth with Unicode from us.
So my recommendation is if there's something in that tree ordinance that y'all would like to see included in here, is that something that can be done, Mark? It's
Yeah,
not
I mean,
in
I'll
there
go back
currently,
and
So
look-
that when it repeals that,
I'll go back and look before first reading too.
obviously
Look
there's
at that.
something that y'all are concerned about. So what part of it
It's
that
not
you're
something specific,
concerned,
I'm just trying to
that you're
understand
concerned about, yeah.
the process here, because he's saying that,
Well-
that we've got the tree ordinance, the historic preservation ordinance, the waterways ordinance, and what was the other thing we were just talking about? So I mean, these are all changing things that we already have as accepted
If
law.
I can add, maybe chime in. Actually, the wording of the ordinance that you use to adopt this and every other ordinance you have should say to the extent of any conflict.
Right.
So to the extent there's not a conflict, your other ordinances would not be repealed unless you specifically repeal them. So if you've got a tree ordinance, the provisions of that don't conflict with this, I'm just using that as an example, would not be repealed unless you specifically repeal that ordinance, the tree ordinance. However, to the extent of a conflict, definition of a tree, protected tree, whatever, this one's gonna
This
prevail, last this point in time. I agree with everything you're saying when you say you can create confusion. I think you're totally accurate when you say that, and I'm not downing Mark at all, I'm just saying that your point's well taken, that, if you've got an ordinance that is being gutted by this ordinance, but there's gonna be part of it that's left surviving, you would be better off to identify those ordinances that this ordinance is gonna drastically impact and repeal them probably, and take the provisions of that ordinance that you think are critical and incorporate them in this, or pass a new ordinance on point, but there is a point in time, especially, when you talk about Unicode, where if you've got the same issue addressed in 5 different places, it gets
Right.
That's confusing.
And so if we're looking at our ordinances and we see tree ordinance, and then this is saying stuff that might not be in conflict, but yet we don't need people to have to look in two different places to find information.
Yeah, I mean, typically, people don't. Usually what happens is, what is people in land development code, which usually in people's code of ordinances is an ordinance that is designed for people to kind of get the tree, Tree City USA designation. And there are certain things in there that you don't include in a land development regulation. And so that's usually what stays in somebody's code of ordinances, keep that designation. But what a developer's gonna look at when they come to town, they're not gonna look at the code of ordinances.
Okay, Mayor, I need, can I please follow on this?
Sure.
Okay. One of my questions today was going to be, how are we on addressing the issues that were identified almost 2 years ago in the diagnostic review? I have that with me somewhere. The staff did a review, we had a joint meeting of this commission and the planning and zoning commission, which one of my comments in the workshop was, I wish that would be called planning and zoning board. So we identified those, and one was enriching the tree canopy. Well, so where are we on that? Because enriching the tree canopy is not just about developers building on unoccupied land or redeveloping land. The tree canopy is a matter of existing occupied commercial and residential property that people that people may need to make changes to or address issues every single day. So where are we in enhancing and protecting our tree canopy?
I don't recall us saying, I don't
It's in the
recall.
diagnostic review. Okay,
Yeah.
it's in,
But I don't think it's part of this conversation today.
yes, it is,
For
because,
land, for land
Okay.
development?
well,
Yeah.
because it's not clear, what is being repealed, the current tree ordinance, that no tree ordinance is just about becoming a tree city. It's about having the objectives, as you say in this document, of reducing runoff, providing shade. Trees are used as a noise buffer, they provide oxygen. So it's not clear to me how these changes that we are making are not just going to direct developers who come from out of town, but how they are going to enable us to protect and enhance the existing canopy that we have. And that is something that we put as an objective.
Well, and I think, but this is a much more extensive tree ordinance and does
No,
provide
it's
greater.
actually not, and you haven't explained what part of 18.5 is being repealed and what part is being kept. This new part is 21 or so, I don't know, 20-something pages long. And, I mean, frankly, there's some serious omissions from there. Like right now, for a large tree, you need a permit to prune it as well. And the rationale for that is that pruning is, you can damage the tree.
They have that in here. That's
I
in
don't
here.
see that.
Yeah, that's in here. I read that about
Where is it
pruning,
that
that
you
you prune it, and it's called, is it abusive? Is it abusive?
Yeah.
Abusive practice?
No, I don't think that's been clarified. It talks about abusive practices, but you don't need a permit for tree abuse, right? You only need a permit to remove a tree.
No, it's, mechanical injuries. That's, there's that, and then it's,
You need a permit to create a mechanical injury.
where is it?
No, there's
I know it's in
use
here.
of commercial and multifamily residential properties on page 120.
Yeah.
This is tree abuse defined. Tree abuse means one or more, or any one or more of the following: removal of more than 25% of the canopy of a tree, or topping or half acting of a tree,
Yeah.
or removal of any lateral branches, leaving the trunk of the tree in stealth appearance, or cutting a tree which destroys its natural habitat of growth or overgrowth.
And it's,
Or pruning that leaves stubs or results in flesh cuts or splintering of limb ends, or using climbing spikes, nails, or hooks, except for the purpose of total tree removal, or pruning of live palm fronds which initiate above the horizontal plane.
Right, and then it goes into your exemptions and the violations and penalties.
Violation.
And I think that's what you're talking about with the,
Oh, that's the $20 per cross.
Right, but it's very misleading because the park code addresses a permit, for a historic tree.
okay, so my recommendation, Commissioner DeVito, is if there's some concern that you have with this.
Yes.
And you are familiar with the tree ordinance and the part that you want, then can you bring that forward to make sure that it's addressed in here?
Well, I will do my best, but.
Because
this is a
it
lot.
appears to me that Mark is saying that he feels, that you feel that this meets all the tree requirements. She's saying that there needs to be, she feels there needs to be something, more. Is that correct, Commissioner DeVito?
Absolutely.
Okay, so that would be my recommendation, that if you wanna get those to Mark and then get it out to us, then we can, because we can talk about trees all day. Everybody has a different opinion on trees, but, if there's something in there, just to make sure that it's all in one document and there's not that confusion that you're concerned about.
Well,
Yes, but, I have just a follow-up if I could before Commissioner Banks starts.
Yes,
And this kind of, so this is a very extensive document. I am very uncomfortable, and I've been saying this for over a year. I am very uncomfortable with a blanket repeal statement when we don't know ahead of time what we're repealing. I've wanted to know that for quite a while. What is being repealed? Our land code.
The whole-
And
the whole code,
The whole
the whole
code.
code.
specifically, if what else is being repealed, we need to know what we're repealing in our existing code of ordinances, and not to have Unicode tell us later that we've done that. And Commissioner Lori has identified the historic preservation issues. I have no idea how anyway, it's not clear how our existing historic preservation ordinance, which needs help, relates to what is in the land development code.
Every ordinance I think we've had has needed help, it seems like.
And this is gonna, you know,
Updated, because this is where we, at some point, we've got to just
Right.
bite the bullet and do it.
and after you pass it, I mean, this is not,
Yes,
Diane will bring
it's not
forward,
set in
so it's not gonna be perfect.
If you look at the number of all of the ordinances we passed since 2007, about half of them are alterations to land development code. I mean, we change it all the time. So I mean,
So it's not set in
We're gonna
stone,
keep
if we
changing.
find something.
it would be great if we had it perfect, but that's not possible. So, I mean,
Okay, but this,
But this-
what I'm saying is some changes are needed, but it is, what is not clear is our existing beneficial provisions of our current historic preservation code, are they being wiped out? For,
I think it's pretty extensive in here as far as the historic preservation.
I don't see in this document any reference to our National Register of Historic Districts.
yes.
Oh, yes, it's in there.
It's right, it's great, it's great.
Where?
It's very
Right,
extensive.
extensively in chapter 3 of the zoning.
Yeah, it's very
And it actually
extensive in there.
points it out, tells the number of contributing structures.
Where is it?
It's in here, I'm just looking at it. Right?
Yeah, no, it's all, it's.
It's in there because the Historic Preservation Board,
And about the historic preservation board and the authority that they have, oh my gosh, they've got a lot of authority. We're giving them a lot of authority, so.
Okay, this is actually a big step to becoming a CLG.
Right, it talks about how many contributing structures we have.
Yeah.
Where?
I'm searching for it right now, give me a second.
While he's doing that, I do wanna ask you this, Mark. So then I can get off of it, and so we can move off the trees. It says in here that existing single-family residential property does not require city notification or permitting if the property owner possesses documentation from an arborist or a Florida licensed landscape architect.
5750.
What we also have here, and that I know a lot of homeowners have run into just in the recent years, is that insurance companies, regardless of whether they're an arborist, regardless of landscape architect, have said, we're not gonna insure you as long as that tree sits right next to your house. You cut that tree down if you want to continue insurance. And so we've got to be able to have something in here to allow them that opportunity also.
Well, yeah, that's language that I highlighted, that is new addition, that reflects state law. We certainly can also say a letter from your insurance company, but I will tell you that it is very easy to get your insurance agent to write a letter to let you take out a trade. The
Well,
guy who's selling you insurance is gonna write you a letter to take out a trade.
well, let me
Even
ask,
if your insurance company hasn't told you that,
okay,
you go
well,
to your
let me
insurance
ask,
agent.
let me ask Dawn now, because Dawn, in your opinion, I mean, because we don't address it in here, that's not part of they would have to, if the insurance company told them to take it out, then they'd have to go get an arborist and pay for an arborist or a landscape architect for a
Yeah.
professional opinion. How do we protect the homeowner?
And you know, the world's changing when it comes
Yes.
to insurance. If you own a home and you don't know that, then you're very fortunate.
Yeah.
Because not only has it changed, but the predictions are for more changes in the near future as insurance companies seem to be looking for ways to avoid writing insurance and avoid losses in Florida, maybe other places too, but particularly Florida. I think that, from my perspective, I think there might be a risk that you want a tree down bad enough that you go get your insurance company to write a letter. I would be more concerned about the risk that your insurance company tells you they won't write unless you remove a tree. You start looking for other insurance companies and find all kinds of issues there in terms of time constraints and number. Some of you probably know, insurance companies are now flying drones over sort of sections of,
That's what they do, and they take a picture and they say, oh, we can't see your house.
over roofs, over siding, over all kinds of things, using that as a basis for denial. So I think you ought to, well, it would sure seem to me that you'd want to build some form of process in there to take into account legitimate demands of an insurance company.
Okay, I like that, legitimate demands,
I
yes.
can answer the question, it's very simple. And I don't know that Mark has correctly interpreted the state statute. The part that says if you get an opinion of an arborist or a landscape architect, you can take down a tree regardless of what the city's code says. In the city of DeLand, the landowner is not prohibited from coming to you for a tree permit. In DeLand, they give the option. You can either spend $100, $150 or more dollars for a landscape architect or an arborist to come evaluate your tree and give you an opinion, or you can go to the city and spend $10 or less for a tree permit, and you can still request a tree permit from the city. And they say that most people use the option of going to the city because it is less expensive.
But what is
they-
involved, what's involved in the process of deciding whether the tree permit is issued?
And the city sends out a forester, you know, they have a landscape architect.
For $10? For $10 they do that?
Well, who knows how much, I mean, that's,
I don't know.
Tree permit, you just
I'm-
have to come to
I'm
the tree
just
board
saying
and explain your
that's-
case, right?
Right, that's what DeLand does, yes. And our code provides for the tree board to get together and to go look at a tree. And that's frequently what they do, that's in our code.
And the tree board they're expert, they have expertise in the issue
No.
of determining.
not necessarily.
Well, there's master
They're
gardeners.
volunteers, they're not, a lot of them are master gardeners, there's not an arborist
So
that sits on the tree board.
if you guys want the insurance letter, like I said, many communities do it, we didn't put it in, but we can. If you guys think that's reasonable.
I think that's.
I would think, I mean,
Okay.
I would think that I like the language that a legitimate demand of an insurance company. Legitimate demand of an insurance company, I think that would take care of that. Commissioner
And it
DeVito,
wouldn't have to be your agent. I mean, they have underwriters.
Right.
And BJ knows something about insurance companies, excuse me, Commissioner Laurie knows something about insurance companies. They have underwriters. And if they have a letter from the underwriter saying, we won't write.
Yeah.
That's more than just your friendly neighborly
Yeah.
insurance agent.
because I'm
Bottom line.
concerned with what you're suggesting, Commissioner DeVito, that if somebody wanted to, they could come in and pretend, for each tree, I've got several on my property, you know, that for each tree, for $10, you can go in and get a city manager or to allow that to happen, and they can clear cut their whole property. This, I think, gives them, I think this, well, you never know, but
Does this apply just to certain types of tree? My understanding is that
This is owner occupied situations.
this is owner occupied.
better not, but.
So owner occupied, and you still have to have a permit to cut a tree on your property?
Well, our language says you don't.
I'm sorry,
Hey,
semantics up here.
And then you have the whole thing of, if you deny it, the tree falls and it causes damage, are you liable?
And that happened, I mean, we had that happen with a
You did?
tree, it went right through somebody's house. They had asked to have it cut for many years and it was denied, and so then there was that situation.
Okay.
So, you know, that could happen,
Who asked for a permit and it was denied?
well, it was a long time ago, and someone said that the owners had said they had asked multiple times for the.
Are you talking about South
Yeah,
Project Tree?
yeah.
I don't think they were even.
Okay, well, if they did or not, it was a long time ago, and they've both since passed away, so. But that was what they said when I walked over there, that they had been asking for this for some time. So anyway, regardless, it could happen. It could happen, so,
okay, so we'll make that change.
okay.
And I'm gonna move on now
Yes.
to subdivisions.
Yes.
Okay. So the current land development code has a lot of very specific details through the subdivision process, right down to form letters for the letter of credits and stuff like that. That does not have, normally, that is not included in modern subdivision ordinances. And so, we did a lot of simplification to the subdivision process. So, but we have, added procedures that will address many of those things. It's called a contract for deed recording, so, it'll occur, as part of the final plat approval process. You know, one of the things that people that are often confused about is when somebody plats and dedicates lands, the underlying fee doesn't transfer to the jurisdiction, right? So while the town controls all of its right of ways, the actual ownership of the underlying, basically, the underlying title is not actually within the town. This is something that can be cured by these contract deed recordings. So they will provide us a bill of sales for all the utilities that they dedicate to us. They'll provide us deeds for the roadways that do get dedicated. In addition, it will have, you'll set forth what type of letter of credit, and we're not specifying the wording, because a lot of times the issuer of that letter of credit will have problems with what is, was written into the land development code 20 years ago in terms of how to form of a letter of credit. They don't want to issue it that way, that it's in the land development code. So you're in a situation, what most cities do when that happens, they just ignore that language that's in their land development code, because a lot of people have very old, this isn't, what Crescent City did 20 years ago isn't unusual 20 years ago. There were a lot of ordinances that said, this is specifically how, this is gonna go. So, and what cities have either done is they've modernized it, as we're suggesting, or they accept letters of credit that are not written exactly, as it's written in their own code. So, the other component, and this is something that's new, and I know we've talked about quite a bit of time, conservation subdivisions. That language is in the, in the prior draft that you saw, and it is in this draft. Did change it a little bit, because the prior way it was written up, it provided a bonus. That bonus actually had a possibility of conflicting with the density in the comp plan. There isn't language in the comp plan that says you can do a conservation and you can have additional bonus density than other than that's applied. So basically what this is, very similar to what was in the previously, but just allows you basically to transfer the density from the wetlands to the uplands. So you're still have a conservation ordinance in there, it still has a lot of the benefits associated with conservation. But we did take out the portion where you're actually providing more density than what the comp plan would allow.
So it's just regrouping.
It's allowing clustering, it's allowing clustering, and in order to achieve the density, it'll let you put together a plan that shows how you're gonna use that density, but you're not getting density over and above what comp plan allows.
And it's on less environmentally sensitive soils, correct?
Right.
So it's not, so the clusters, okay.
Yeah.
That's less, okay. You already went through with that?
Yeah, and so that's really everything I wanted to highlight.
Okay. Commissioners, at this time, then, if Mark is done, if y'all have any, if there's anything that you, need addressed, let's start, let's go through it.
Can I ask about the signage, the sign ordinance? Is this just how we had it before?
It's largely your existing sign ordinance.
What's largely?
We might have cleaned up, we didn't change any substantive standards, if we changed anything in it, it's obviously reformatted to fit our format.
Some of the definitions are what we
Yeah.
talked about.
Yeah, I mean, I didn't highlight this, you know, the definitions that are in this version versus the draft, far less, there were many definitions in your last draft that aren't actually used anywhere in this document. So we eliminated a lot of this, that's that last article, so yeah.
Mark, as you clean this up to bring this back to us, would you just, and use a different color for anything that you've added or omitted, strike through, so that we know what, we don't have to necessarily reread the entire thing over again, so that we can see that, is that possible?
From the changes that you
Yes.
identified today,
Any
yes.
changes that we've identified, yes. Does anybody have any?
No, but I appreciate that, thank you.
Yes, Mayor, I have some questions.
Okay.
So, it's not clear to me that all the changes that we identified in our workshops were incorporated into this document. Did y'all make sure, we had a number of hour-long to 2-hour-long workshops. And I know the mayor had identified some changes. We all had changes. We had changes on accessory structures. We had changes, the mayor identified a very important issue with regard to height of buildings and height of accessory
I think
items.
that's in here, when I got through it, it looks to me like
Is that in there?
it meets
Okay.
that.
Because one item that I did not see that we had a lengthy discussion on was regarding the Planning and Zoning Commission. We talked about that they needed to be residents of the city. We talked about what a quorum was.
It's on,
It's in there.
so that's very specific.
Where does it say resident of the city?
And
And I know for a fact on the historic board, it has to be a resident of the city, and,
supposed to have some sort of censorship.
I'm pretty sure it said that on the other too.
Almost all of it.
And, yeah, there was a draft that said that you could be a property owner and the, planning zone, but that was, we discussed that too now. And that is what is reflected in here, from what I inherited to my copy.
It has
of
the
it.
quorum
It
information.
has
Has a
more
form,
information.
yep,
It says that.
and it has to be, like, even it goes into detail that it has to be, even if you have a quorum, a lot of the decisions have to be a majority of your board.
It's page 11, Mark. Here, page 11.
How to get this to jump to.
Yeah, this, the last draft didn't have it kind of clear. It explained everything and it kind of re-explained it all with the planning and zoning commission, but this has all been, I mean, you did a great job cleaning this
I think
up.
it's on 2.4, is it 2.4?
Yeah, it's 2.4, page 11.
Um,
And it says that their terms begin January 1st and expire on December 31st, and that no fewer than 2 nor more than 3 terms shall expire each year. And then that they choose their chairman. I mean, voluntary absence from 3 meetings during a calendar year shall constitute resignation. Vacancies shall be filled by the city commission upon the affirmative vote of the majority of the full city commission membership. The city commission removed with or without cause a member of the planning and zoning from office of the public.
I don't know if maybe it says,
I don't see resumes.
yeah, maybe
I don't see that at all.
I know it's in the historic, that the historic specifically states that.
But I don't see that here. And we have a lot.
So we need to add, so I would think we should add that should be, and you could do that, shall have not less than 5, and B. And that membership should consist of residents within the city limits.
Having 6 members is a problem.
Okay. I thought we decided it would just be 5
5.
because with the
Just
historic.
no less than 5 or more than 7. we
I
can do
saw
that.
that, yeah.
No less than 5, no more.
We used to have 5 and 2 alternates, is how we were operating for many
6
years.
is just even numbered,
Correct.
tie votes.
But, and the thing is that historic preservation is the 5 members plus 2 additional members is the way it's in there. So I mean, we could just change it to have it be 5.
Right.
Is that what you guys are saying?
So you have a separate planning commission and a zoning board of adjustment
No,
No,
that's all together.
all together, and
Planning
they,
planning and zoning commission.
And this language doesn't say it's gonna be, it just says between 5 and 7.
yeah, I was just asking you, so they consider both such things as
Zoning-
conditional uses and rezonings?
Yes.
yes.
We don't separate.
And then we have our historic board, which has
And-
2 additional members,
And most places have been eliminating them.
and that's 7, so that gives 7.
Eliminating one.
I just can't hear what
Yeah,
I'm
most
saying.
cities have been eliminating separate boards of adjustment.
I'm sorry, I can't
Or-
hear
can't
what
hear you,
you're saying.
If both cities are eliminating having 2 separate board of adjustment and a planning and zoning,
Or just
They just have
planning,
one.
planning board and then zoning board.
Yeah.
Which that makes sense. I don't know why you didn't do that.
Particularly small cities, it's hard, first of all, the board adjustment doesn't meet as often, it's hard to staff it. So it's for,
Just wrap it on.
And the Attorney General has specifically stated that you can't have the same members, be members of both boards now. They call that dual office holding.
Right, I know.
So, you can give the same board all the responsibilities of both boards, but you can't have a ZBOA and a planning commission and have the same people sit on both.
Okay, well, let me ask you this. We have that, and then we have our historic board, which we have the 2 additional members, plus the planning and zoning. Is that going to create that overlap? Or would we have to have an entirely different historic?
I think the question, the question had to do with dual office holding, and they found that a board member of planning commission who was also a board member of the ZBOA was holding 2 offices, and that was not allowed. So I don't know why the same analogy wouldn't apply to.
I would think that would apply to that as well. So my question is, that's something we need to think about, that if we call it the planning and zoning and historical,
does this new historic language talk about the composition of the board?
Yes.
yes.
yes,
What
it
does
does.
it say? Does it say it's the planning and zoning plus 2?
Plus 2, plus
Yeah.
2 members. Who are really, their only voting right is only on the historical matters
Right, because
and not on the
Yeah.
other.
they don't sit there up here during the planning.
But it sounds like all P and Z members are dual board.
Yes, they would be be dual, so that's an issue.
Ma'am.
Yes, Commissioner Becky?
No, I'm sorry, I'm not here. You can have a board, and it has responsibilities to consider special exceptions and rezoning. That's not a problem. You just can't have a ZBOA board that handles variances, special exceptions, conditional uses, which are generally termed quasi judicial, and many jurisdictions have them appealing directly to court. And a planning commission, which is primarily making recommendations to this body for rezonings, PUDs and things. You could have those 2 boards. You could have one board that is doing both functions, but you can't have the same board members sitting today as planning
2 separate
commission and tomorrow as ZBOA.
We have,
And that's our
our planning board sits as our preservation board plus two new other people. So they've got two positions. They're a planning board member and they're a historic preservation board member.
I'll get the AG opinion, but, yeah, I'm afraid that's gonna be, I don't know why that would be different from the dual office holding that they admonished against.
So if we did that, then that's something that we probably should consider, is that we combine those into one board.
We just had to address it in interlocking. Traditionally, small municipalities have trouble getting volunteers to fill a lot of slots. And so Interlochen was looking to do, call their members, the volunteers they had, they'd both sit as a ZDOA and sit as a planning commission. So we started doing some research, found an AG opinion and said, so we're just redefining the code and making this a board that's gonna hear both, variances and special exceptions and planning commissions. It's gonna be, but it's gonna have one name, they hold one office. Of course, the problem there is you're having to give them the different standard. You know, one of them's a quasi-judicial matter, one of them is a legislative function or a recommendation leading to a legislative function. So it has its own set of problems, but
Well, let's let him, I know y'all are, there's a lot of mumbling over here, but I'm trying to concentrate and let him finish, so let him finish.
that's not finished, that's all.
Yes, and I was trying to say something.
Yes,
That I believe in our 2018 historic preservation ordinance, the wording of that ordinance, which I don't see anywhere here, was that the planning and zoning board would provide the historic preservation function. It did not create a separate board. I think that was the way it was originally structured.
That's
So-
fine.
So it might be fine legally. I have to go back and check whether you can be a state certified, you know, because we're trying to create this so that you can be, you know,
right.
certified. And so I
May have to be a separate board.
may have to be a separate board.
I never heard that. I was told long ago that it could be the same board, it could be the CLG.
Oh, let's let them
Right.
research this, because
Well,
that would really kind of throw them.
So, yeah, so we need to, so that,
Yeah, I'll have to change that.
if that's the case, then we would have to leave it at 7. But maybe what we need to put in here is that it needs to be of an odd number.
Yeah, I mean, I think
So I know there's.
mechanically
language where you do
within
that,
the document, we
the
have
board
historic
must be of
preservation.
odd number membership. So,
Yeah.
okay.
You know, the way we've addressed other where the dual boards are, we basically just, there were two different, the code talks about two different boards, but it basically just said the planning commission is the board of adjustment.
Okay.
Yeah,
And you can do that.
and so that's,
That doesn't run afoul of the.
Right.
That's not currently how we have it structured.
right, so,
We're five planning zoning, then afterwards, they have the historic preservation board meeting and 2 more people get up there. So that would be the 5 plus the 2, so.
so if I have to change it, the way it will come back is planning and zoning commission will have 7 members, and we'll have very similar language for there'll still be this language that talks about powers in the historic preservation board, but there'll be something, there'll be a line there that says it is the planning and zoning commission.
How about do you have a CRA agency?
We are the CRA.
We are.
We are the CRA, we are the board
The
of the CRA.
commission is.
And you don't add anybody to it?
No.
No,
Low all of our stuff.
can we do that?
Really.
Y'all
You know, I was
on that
thinking,
too?
City of Malacca does it, I mean, their enabling ordinance provides for that. Yours probably does too, so. It does. It doesn't?
May I have a question about?
Oh, no, I mean, that this board would be also the CRA.
Oh, yeah, but it doesn't provide that there'll be a representative.
No, I don't know, I have to go back and look at it. I knew that the statute, the charter in which City of Malacca operates requires that they have 2 other people, one of whom should be member of the county commission.
But that's an option, I mean, that's not what, ours was just this 5 of us, I think.
Yeah.
Yes,
I
Commissioner Tejeda?
Yes, with respect to historic preservation, if you look pages 56 through 57, 58 in the proposed land development code, it's, I think our current 2018 ordinance specifically protects structures in the National Register Historic District from demolition. This land development code has some very good provisions in it. But it appears to me, if you look at all the provisions and the way they fit together, that nothing is protected from demolition, alteration, or relocation until the city takes an affirmative step to designate you. So,
What?
right,
Because
Okay.
when you look at 3.17.9,
right,
so I'm lost.
okay, I'll help you out, all right. What I'm seeing is, it says, 3.17.9.
Evidence on the need for demolition.
Okay, but for protection from demolition, okay? This is evidence of the need for demolition. What I'm concerned about is back in 3.17.4. Well, just the way this is structured. It says properties listed in the National Register of Historic Places. Okay, that's individual properties that are on the Department of Interior registration, and I think the only one in town is Molly Morris's house.
No, that's,
Or,
No, the Craig House is too, I believe.
no, it is not.
It's not.
Okay.
we just have, we have
I just-
Molly Morris's house in the district.
Right.
Just the district, so
Yeah.
the Craig House is not, because y'all been saying,
No, no, no.
I thought had been
It
saying.
qualifies for listing.
Okay, could I clarify what I said in the prior meeting? There are 3 buildings on Central Avenue that possibly, they're listed in our historic district. Documentation is saying they qualify for listing in and of themselves, but no application has been made. And that was, so potentially they qualify. So what I'm concerned about, it says properties listed in the National Register or in the Florida Master Site File are presumed to meet the above criteria and shall be classified as designated historic sites.
And everything that's in the district is listed in the Florida Master Site.
Site file.
Yeah.
Okay, but so when does the protection from demolition attach? Is it sufficient? Is it sufficient if it's in the master site? If it's in the master
It
site
says
file?
criteria for modification, no demolition, alteration, or relocation of a historic structure shall be permitted except as provided below. So I mean, it says any other property may be classified, but it says that includes everything right there.
Okay, because Lupita was telling us that none of our properties qualified for protection from anything.
Well, not currently, because we haven't adopted this.
Okay, but our current ordinance protected.
I'm just-
You two, y'all been going back and forth. Commissioner DeVito, please finish. Commissioner Lori, then I'll call on you, so for you, for clarification, please.
What I would like to make sure is that we don't have to go through an additional step to have the protections from demolition attached. That's not clear to me.
I don't think you do.
Okay, well, somebody needs to tell me that, and then, I'm not sure if this is correct, it says 3.17.5, new construction on historic sites.
That's right.
Do they mean in a historic district? I mean, if it's, I don't know.
Commissioner Lori, you had some language,
I don't know what that means.
I thought you had some language that helped her with that. Didn't you?
No, I'm sure.
Okay.
I'm just looking at this, and this is much better than our current historic preservation ordinance.
It is just more thorough.
Yeah,
Yeah, that's thorough, and if there's a larger piece of property and somebody wants to add something to it,
That's what you're talking
you know, that's what you're talking about, you know?
about. My one question was, I didn't see anything about demolition by neglect. Is that in there? Or is that something we can add? Because that, I know that's one of the requirements for a CLG, is that you have provisions for demolition by neglect. And it's kind of a big thing that we didn't have before.
One thing that's important to note is we don't have enforcement authority in a national registered district, even to prevent demolitions. You have to have a local historic district that has those rules and be a certified local government to establish that district and adopt those rules.
And
Do that.
So even as a CLG, we can't enforce anything in the national registered
So we
district.
have to have an ordinance to become a CLG.
Okay, and
So that's-
why is that? That's.
Because National Register is an honorary designation, has no teeth. And just,
Okay, but what about our ordinance?
I don't think we have the ability to do that, especially unless it's a local historic district that we've created and the members have voluntarily agreed to put themselves under those rules.
Those rules can be pretty strict and basically unaffordable for a lot of people.
And they can also be very, very loose,
Right.
depending on what you adopt.
But we were talking about demolition.
Oh, is it?
You either demolish or you don't.
Yeah, I don't believe we have the ability, unless Donnelly gets back, to prevent a demolition.
You told me we did.
Not
We don't-
only a local historic district. If we have a local historic district and it says you can't demolish,
I mean, this whole thing is saying that we can issue certificates for appropriateness and that you have to get a permit to demolish a building.
once you're a CLG and it's a locally designated district or landmark.
I mean, this says that everything that's
Yeah, but you will have to get the certification, and you need to have an ordinance.
that ordinance first,
Yeah.
right? To get this.
So, yeah, this
We
is the
even
only
talked about
effort,
that.
this is the only reference to demolition by neglect. So educating citizens of signs of demolition of neglect.
Okay. And do we have anything as far as penalties for violation of these provisions? Because I know those are, I have to check, off the top of my head, I know that we have to have a provision for prevention of demolition by neglect, and then there be some consequences for that, as well as for demolishing a building that,
Yeah.
without demolition permission.
I'll have to look at that. This is,
There's like 10 things that you have to have for CLG. We got most of them in this, I think, but, and a demolition.
I have a lot of good general knowledge, one area where I admit that, I don't know these things off the top of my head. When we get to historic preservation.
That's fine.
I worked in Wilmington, North Carolina. They had a whole staff that did that. If you went to lunch with them, you'd talk to them about wind mullions for an hour, and I would just drift off. But I will research that. Like I said, that's the only reference to it.
So, and I just, for clarification, and I guess the whole time I've lived there, I've heard this over and over and over again. They only had two structures. And it was Molly's house and it was the Sprague house. So you're saying that the Sprague house was never,
It's a contributing structure to the
but
district.
it was never
It's not
on the
listed.
National Historic Register.
And neither is the school, I believe. A lot of people
That's
say
the
the
school
school
not.
is,
Okay.
It's a contributing
It's
structure, which they
Molly's
said, and
Is the only.
Okay, I'm just saying that I've heard that since I moved here, is that those were the only two. And so that's why I'm asking for clarification. Please don't blow your mind at me.
I'm not rolling though, I'm saying
and
it's,
Yes.
as you frequently said, what you hear sometimes is not correct.
Well, and that's why I'm asking.
Yeah, I'm saying.
It's to make sure, so now we have clarification that we only have one.
Yeah, and I'm gonna say something off the cuff because that's the way I like to talk, basically. But the Sprague House, which is a building I think that really should be preserved, is not being preserved. And I would say it was probably within the next 5, even 10 years, but I would say even moving along to 5 years, that whole building will have to be demolished. So, it's real easy to say, okay, let's put these rules and regulations and all this kind of stuff that says, hey, don't demolish this and gee, you'll be fine if you do. But if the building is not being maintained to begin with, those things probably are gonna go down. And you'll replace it hopefully with something that's historic looking. But the building itself probably will have to be demolished. So these are things that we have to start considering here in Crescent City.
Yes, so it shouldn't be it. And that is why I've been highlighting the historic district, and I was hoping that the Main Street process would start addressing preservation of buildings. We haven't got there yet. That's why I brought up the federal historic preservation tax credit. I agree with Commissioner Burton, we need to start putting some attention to preservation on Main Street, which is, I understand, the title of the last conference. We need to put our shoulder to the wheel to come up with what we can do and what we can do to inform and help the property owners. Because yes, that that building is in danger and a lot of other buildings are too. That's absolutely right.
So, are we?
Okay,
You wanna
wanna
proceed?
No, I mean, while we're on it, I had a couple of questions in here. We had in here submitted to the building director. When you look at the 3.17.5,
We probably just missed that one.
Yeah,
okay, so I think that that's submitted to the building director, so that's something prior to review by the planning and by the, P&Z board. And that says planning board, I think we should probably put the P in,
we've tried to, we eliminated a whole number of
I know,
planning.
I know,
zoning
I just-
boards. But
And then that's down here where it comes down to also the board shall find the new site feature would be hidden to the greatest extent possible and or appropriate and compatible with the balance of the site and adjacent historic sites. So this is for, like you said, anything that is wanting to be built, not necessarily on a historic site that is vacant, that has been vacated, but it's something in addition to what's currently standing. Correct. Is that correct? Okay. I don't know if there's some clarification language that we could put in there to where it shows that, so there's not that confusion, but that could be, Commissioner DeVito, you want to continue with your list?
So I don't think I have anything else.
Is that all you have?
I think so. I have a couple of questions for Mark, but, I mean, I just want to know that everything that we discussed in our workshops has been added, that's what we had the workshop.
Or starting litigation.
Commissioner Lloyd, do you have some questions or some?
I was just going to say that, I mean, I compared my copy of chapters 1 to 2, or 1, 2, and 3 to what you have here. And it's almost, it's exactly the same, except for there's a few things that you talked about, like the CBD was.
so we tried to capture everything. Did we get everything? I hope so. You know, a lot of what I've been doing has been looking for notes. I've gone back and looked at some YouTube stuff. You know, so, I mean, just so you know, part of my issue is you know, Lupita is no longer with us, so I have her notes, which were pretty good, you know, and I've listened to YouTube, but sometimes
And I spent hours
it's
correcting these files and sending them to her, so. And you've used the files that I corrected for the most part, so.
yeah.
So do either of you have anything? You're good, Commissioner Burton, you're good? I have a couple, just if I can go through them, just for
Sure.
some clarification. We've got, if you go to 1.5.2, and it says, any and all other applicable city, state, and federal regulations. I guess with county, we don't need to include county in there. Just in case, especially since,
I mean, there's, most of what the county that would be applicable is kind of through the health department, which is covered by the state. I mean, I could throw county in there.
I'm just looking at it, if somebody was to challenge us and it says, well, this is what the county requires. And it says, well, it doesn't state it in here that I have to adhere to what the county, it's only the city. I don't know, Don, is that,
I mean,
You build on the county road, you have to get a county driveway.
yeah,
yeah,
so I think that we should want to include that. If there's a couple of places in here and I'll bring that to you, after the fact.
okay.
Where we need to probably add that. And then if you go to, if we go to 1.7.4.2, appeal of determination, it's an applicant may appeal to the city commission, the city manager's vested rights determination. I wonder if it would be clearer if you said any applicant may appeal the city manager's vested rights determination to the city commission. Just for,
Can you
it's
repeat what-
1.7.4.2. It's on page 4.
Thanks for the page numbers, by the way. What's it called?
Yeah, that's very helpful.
A, show my A.
Yeah, an A. It's just flip-flopping it.
Okay,
They appeal to the city commission, this just says what they're appealing to the city commission. Yeah.
To the city, yeah.
That's his rights.
Yeah.
And then, let's see,
What does this times jurisdictional means? And what does that mean? Can someone explain that? I remember reading that this time is jurisdictional. It's within 30 days following the rigor of city manager's best direct determination.
I mean, if you miss it, it's not waivable. If you miss it, there's no more jurisdiction for the appeal.
yeah, but it doesn't matter how good your argument is, if you're in, if you're 2 seconds late appealing the falling off the,
falling off the beam.
Yeah, the beam.
Whatever.
doesn't matter.
It doesn't matter. So if you go to page 6, and it's under B, and it says the LDC fails to comply with any timeframes for established development, it says development established. I'm just wondering if it would be for established development, the plat, site plan, or building. I'm just asking if that would be,
Where is that?
it's
For
in
development
6,
established.
on page 6, 1.9.4, it's B.
1.9.
With any timeframes for established development, the plat, site plan, or building permit, rather than the for development established. And if it doesn't work, Mark, this is just something that when I was reading through it, it just,
I guess what you're
Okay.
saying that
Yeah, all right.
you see?
Yeah.
And if,
Um,
tell me when you're ready, and I'll try to rush through these. When we go to page 7,
Okay,
1.10.7, deteriorated structures or structures damaged by fire or other natural forces may be reconstructed at, but not to exceed. Typically, you've got that 50%. If it's damaged up to that, 50% or more, and we don't have that in here as some protection.
okay,
And then if you go down, so I don't know where I'm gonna leave that up to you, but I have that in there. And then when you go down to, it says the affected structure as rebuilt or replaced complies with all applicable federal and state regulations, city, building, and life safety regulations. So it would be, probably, a county does they do all of our building permitting. So again, that's where I said,
yeah, but you've adopted these codes that they're enforcing.
okay, I just wanna make sure,
Okay.
I'm just.
Yeah.
And then, I had it, a non-conforming lot is contiguous to another lot in the same or substantially the same ownership. Such lot shall be considered to be an undivided parcel. Does that, if they're already undivided, I guess I just wanted some clarification.
Basically, what this is saying, if you have 2 non-conforming lots, so
Yeah.
neither one of them meet code requirement, and they're in the same ownership,
Yeah,
you can't sell one off and make it be buildable. If you have 2 non-conforming lots, you basically have to keep them.
so you have to combine them,
Or
basically.
they're treated as combined.
Okay, that was just, I needed some clarification on that. And then we go down to, on page 9, and this is something that comes up, and this comes back from the legal days of years and years ago. We have 15 days, is that 15 calendar or 15 business? And I think we probably need some clarification in here, just to, I don't think that
in the definition.
I'm not sure if it's in.
Yeah, I think we treat, but yeah, it will be business days, but I agree, I thought we had clarified that, but I will check.
Yeah,
Normally, legal interpretation is unless it specifies business days, then it is calendar
it's
day.
calendar, it falls on the calendar,
So is
yeah.
that something that we just put in the definition, saying that days?
If it says business days, then he's good. And excluding legal, you are also going to exclude legal holidays. So if if you intend for it to be business days, then it should be excluding all federally recognized legal holidays.
Okay,
Actually, we're gonna talk about holidays, we might want to say city holidays, because I think we have more done for city and federal, we have maybe more done for federal, I don't know. Because you could hardly.
and we might just want to keep it calendar, I mean, Dawn, what would be just keep it at calendar and just follow calendar days?
If the time frame is, I'm reading it now,
Yeah, see, yeah, you probably want to keep it as short,
then I would just keep it calendar days.
Okay,
it's to the advantage of the city to keep it as short as possible.
so we just need to make sure that all days reference our calendar days.
Is that, yeah, but then the definition is.
Yeah.
Yeah.
Normally, if the number of days is like really short, 5 days, especially anything 5 days or under, then you do specify that it would be work days excluding all, weekends and legal holidays. But if it's more than 5 days, it's very discretionary. At 15, I wouldn't have a problem with it being just calendar day.
Calendar, okay. And that's typically in here, it's 15 or 30 or 60. So then you go to page on 9, that same one, where we've got at the very end, it says de novo. A lot of people will not understand what that means. That's a very technical term, deciding issues without reference to any legal concession or assumption. So I don't know if we want to put something else in there for.
Where are you
de novo.
going there?
Right there,
Last
see at
thing,
the bottom,
appeals
de
to
novo.
city commission will be denied well.
Well, but that,
Is that-
sometimes when you start trying to dumb down
So
words
you're
of art
okay?
that have an established legal meaning, you open up more cans of
So
worms.
leave it that way? Okay.
The
let's do it
courts,
that way.
the courts understand what that means.
Okay. Go to page 11.
I'm gonna stop getting up, I'm just gonna stay
You don't have to
here.
get up. So to go to 11, and it says to appoint and remove members of the Planning and Zoning, Historic Preservation Board, Trees and Code Enforcement Board. We also have our magistrate, and I don't know if we need to include that in here somewhere.
But we did leave the code enforcement board.
We left it there, but we also have that.
But we would be removing the magistrate.
Let me see what,
I mean, we can't.
We could cancel it.
where are you at now?
And I'm just asking.
What paragraph?
It's E on 2.1. And I'm just asking, I'm not saying this is what we need to do, I'm just saying, is this something that needs to be included, or if it does not, then that's fine too. It just stuck out to me.
2.1, I don't see where you are, Mayor.
11, on page 11, E
Okay.
at the top. It's the only E on the page. It's not E,
Oh,
it's not E,
it's
it's actually D.
Was it?
And so I don't know if we need to,
Well, so what's the context of that? That's a subparagraph, what's the?
These are the powers and duties of the
The board's.
board to appoint people. Do we need to add the magistrate?
So could you go back up to the introductory paragraph, please? There.
Well, it's powers and duties under the land development code, so is our code board now, or are our code functions all contained in land development code?
Good question.
No, because.
No.
No, it just,
Okay, then why is?
It wouldn't be applicable then, it wouldn't, that does
okay, I just want to make
specifically
sure.
relate to the LDC.
Okay, I just want to make sure.
See, this is where it's getting confusing
Um,
between the LDC and the regular set of ordinances.
So then you come down, and if you come down to 2.4 mark, and it says shall serve, each member of the Planning and Zoning Commission shall serve until the expiration of his or her term. Would that preclude us from removing a member if we needed to remove a member? Because it's very specific, says they shall.
It says also that we can remove them for cause.
It does later, but it
Yeah.
doesn't. but-
No, I don't think it precludes you from doing that.
Okay,
It's
I
a
just,
normal operation.
I know, that's okay. I want to make these are just things that,
But
We need to
oftentimes you'll put
clarify.
oftentimes at a location like that, to your point, you'll put a clause that states unless removed as in accord with paragraph blank above, you know what I'm
and
saying?
I wrote that in here, unless removed, until the expiration of his term, unless removed, blah, blah, blah. So I did have that in my notes. That's why I wanted some clarification.
So that's 2 point what?
That's 2.4
Yes,
C.
ma'am. 2.41
Yes.
C, yeah. 2.4.1,
C.
yes, sir.
Hold just 1 second. Yeah, I would definitely put a thing in there that states unless removed under applicable law or rule, just keep it generic, unless removed under applicable law, ordinance, or rule. Because they could be removed for something else, ethics violation.
Yeah,
Could be done by the government, could be done by whomever. Hopefully it doesn't happen, but yeah, unless removed under, you know, in accord with applicable
Where is,
law, ordinance, or rule.
where is this? I know I wrote it,
See,
so that every,
it's
not
on-
every remove them can remove them.
And yeah,
it does, but this,
No, I'm just wondering where
He's
it was,
saying
so we can
clear.
refer to it. Because it says, because it's saying that.
I think it was
yeah,
under what their, authority was, wasn't it?
Or is it under our authority? for the city commission?
it's under their, it's just generally, and it talks about,
It says to appoint and remove members of the planning and zoning commission, that's under paragraph 2.11,
G.
and that's under A,
Oh, no.
excuse me, D, 2.11D, to appoint and remove members of the planning and zoning commission, historic preservation board, et cetera. So, you know, you have it in there, but if it were me, I would put that in there. It's not a bad point for clarification that it's because it says shall serve to the expiration of his or her term, put a comma there and just say unless removed, in accord with applicable
I like that.
ordinance, code, or,
I think just for the protection of that, just in case somebody
Okay.
challenged it.
Something that said they can remove we can remove for cause or without.
It does, it says in there that we can, and it does say cause or without cause, but it's just,
I was just thought
if
that.
somebody was to use this and say, well, they're conflicting with one
No,
another.
I'm just saying that's what we should probably refer to.
Well, he was saying, what Don was saying though is that it could also, something else could happen, they could have an ethics violation, they could get arrested. There's other reasons other than just, and then when you go to 12, page 12, on E, it says a voluntary absence. I think that without an excused absence, that would constitute being, so they could have issues and their board could agree to excuse it.
Yeah, I think we,
Show up for-
that's one of the items I think we, addressed in the workshop. I think we went over that. I wrote a little note here.
Yeah, that's why I'm making sure it's in here.
Right, no, I appreciate that, but I'm just saying, I think we went all through that and somehow didn't wind up, so thank you.
And then we come down here at least 7 days. So in this, Mark, we have it somewhere else in here, about meetings. So if you go to page 13, it says at least 7 days notice shall be provided for any meeting on an agenda for the meeting and the agenda for the meeting shall be available. You have later on about meeting and, I don't know that if that's 7 days, that's very specific. Sometimes our agenda is a day early or a day late. I don't know, Charles, you work with this, so with the meetings, you and Karen, shall be provided for any meeting and an agenda. So what if they had to, they had a special meeting, maybe called by a chairperson, but at least 7 days notice shall be provided. If we had to call a special meeting, we have to do the 12 hours, correct? 12 hours. So I don't know, I just wonder if that was,
And this is for finance, so-
Yeah, we're usually 6 or 7 days.
yeah, so just look at that, there's language further down and I'll find it where it's, it's not as, specific, but still gives proper notice.
So that would prevent you from calling a special meeting without 7 days' notice.
Yeah.
And the state statute has not been interpreted in that fashion. Just FYI, the state statute has been interpreted that you can call a special meeting or an emergency meeting with what is deemed reasonable notice under the circumstances, which at least 3 days has been upheld multiple times.
This doesn't affect you guys, by the way. This is just the Planning and Zoning Commission.
It does affect us. That's planning and zoning is under us. I'm not saying
Yeah,
about us.
no, I'm just saying
about
it's-
planning and zoning.
right.
though. So if planning and zoning needed to call a special meeting for whatever reason, something could happen. I still, or somebody, if that is not out right at that 7th day, there's gonna be some criticism and it would throw everything off.
I would argue caution when you're talking about giving your zoning commission the ability to call emergency meetings. I understand you should keep it, you should
I'm
keep that
more
on.
worried about the 7 days, that if you don't do it within that 7 days and somebody calls in on it, it's 6 days, that the agenda goes out, and then somebody calls them on it, and you gotta kind of start all over.
7 days is pretty much traditional.
Yeah, it is, and they try to do that, but,
I mean, other counties, cities.
and that's fine, if everybody is fine with 7 days, and
We can amend the agenda right after it goes out.
Not if it's gonna bring up something entirely new. I mean, there's normally if you can add an agenda item that's totally new, then basically you have it provided 7 day notice, as was required. But for land use decisions, I don't think it's a problem.
We're gonna get
keeping the
blasted.
7
Change
day
that to 5
requirement there.
or something more. Can we lessen that number just so that we're not blasted if we're not out within 7 days of
5 days,
beforehand?
no later than 5 days.
You're talking about zoning decisions, and you know what happens if people don't get notice of a decision that affects a neighboring property. And so I don't know, I
So you think we should leave it at 7?
think
That
that's
would be your,
traditional.
that would be, okay.
That's traditional. A lot. I don't know, yeah, it's traditional, 7 days.
I just was,
You do miss agendas, and sometimes you have to roll it over to the next month, but I think the thinking has been better that than, risk rushing one through and then having people say they didn't get a notice of a change that affected their property. Affected
The
their property
property owners
value.
will have, I mean, if they're neighboring property owners, we already sent them by mail, right, 15 or 30 days beforehand.
Yeah, I mean, this is, we can put a different number.
I'm just asking,
It's
I don't
just-
want it to,
it-
we don't need to get bogged down into it, I'm just asking. If we go to page 14, 2.5.3. So I just want some clarification on this. The board may then either continue its review, forwarding its recommendation to the State Historic Preservation Officer and noting the owner's objection. So they would do that without it coming to the commission for any approval, correct?
Yep.
And that's standard procedure, correct? Okay.
Where are you on, I'm seeing the paragraph, but I'm just not finding the sub-paragraph.
At the very bottom, it says, on D, it says the board.
D
may-
is in David?
Yes, sir, at 2.5.3 D, that the board, that being the Historic Preservation Board, would continue its review or, send it on to the state.
Gotcha.
Do you have any input on that, Tom?
No, I mean, it's for you, it's a policy decision for you to decide whether you're gonna delegate that authority to them.
And that's what we're doing with this, is we've
That's what
delegated
you'd be
that
doing.
authority to them. And so if everybody's comfortable with that,
It's kind of standard practice when you're doing a nomination for the register. And usually the the keeper of the register will not enroll it if there is an objection from the property owner that's notarized. I was just reading about that. So.
I know, it's just the objection part just concerned me that they might not have the opportunity. Yes,
So in A, it says appeal, that the property owner could appeal to the city commission if they wanted to. I think that's part of that process.
unless appealed to the
Or is
city
that,
commission.
or is that a different process?
That's, yeah,
That's for certificate of appropriateness. This is about the one, nomination to the national register. does a notarized real estate on a specific report. As far as I understand it, the keeper of the register or the SHPO will not allow it to go on if it has a notarized obstruction.
Is that- Charles, are you familiar with that at all?
I've not been through that process.
If we go to, are we taking care of that upon receipt of the complete application? We've taken care of that. This is, so like rezoning application, and you've got this in here several places.
We're,
Let's go to 19. Page 19, 2.8.5, reconsideration. A rezoning application denied by the city commission shall not be eligible for resubmission for a period of 1 year after the date of denial.
Pretty standard.
That's standard, okay, I just want to
Pretty
make sure because,
and just so you know, it's for the exact same thing.
okay,
If they, for example, if they applied for commercial and you denied them, they could come back for residential next month. But this language is here because there are some people who will
Do the same.
just keep doing it.
And they can always also appeal to the circuit court.
Yeah.
We can, right?
okay.
Which doesn't sound like a cheat.
Okay, property that is subject to the proposed amendment not located in the area code. Here it is. I think it's in the decision with respect. If we go to page 24, and if we go to F on that page, the decision of the city commission with respect to the small scale amendment shall be effective 31 days after its adoption unless appealed. Should that be to the courts by an affected person as defined in current Florida statutes? Just so they know who it appeals to, who would, unless it's appealed to the,
Yeah, it's actually the state administrative.
okay, so could we just add that? Huh?
It's okay if I make it.
Oh, Rachel,
That's why she came here.
He needs
to.
I'll just come up with it consent.
okay.
Could you come up and give me one too, please?
Sure.
I have peanuts. You can't, I know you can't eat those. And I think,
So we going in now?
so if we go to, page 26, and it's 2.14.1, an annexation decision is a legislative action. I wonder if we should put commission legislative action, only because when somebody's reading through this, and I'm trying to look at it as the general public, that they're thinking, oh my gosh, it has to go to the legislature. I mean, we understand what a legislative action means. Should we put on there the commission legislative action? And again, I'm just asking for, we've got that in there a couple of places, 2.15 also, involuntary annexation.
So if I could go back 1 minute, your appeal process is already explained in 2.1, 2.6
Okay,
as to where it's appealed and
so
how.
we don't have to include that.
I would
Okay,
not, I
Okay,
don't think it's necessary that you go back to subsection F to deal with it because it is dealt with in 2.1, 2.6
okay.
specifically. I'm sorry to interrupt, I just
No,
wanted to
no,
point that out.
thank you for clarifying. That's all I'm asking is for clarification. And so, and you did you look at that, Mark? Don, did you hear what I was talking about?
I'm sorry, I was looking at
Yeah,
that, where was
the
it?
It
word
says
about-
the annexation decision is a legislative action and shall be administered accordingly. And so I'm asking, should we put commission legislative action, or just legislative, only so that the general
What
public,
paragraph is it? Where are you?
page 26, 2.14.1.
Okay, sorry, 26.
The only thing I'm concerned about is for the general public that would read that and think legislative, we know what that means, but a lot of people don't understand that that's our role, and should we, I mean, you don't have to, and if the commission doesn't want to, it's there in 2.15 legislative action. Don't want people to think they have to go to the legislature.
And Mark, at the beginning of each chapter, those lists of headings are supposed to be table of contents.
Yeah, so, I mean, this is really actually written, it's gonna be online, right? So you're gonna be able to link it, go through, it's written for codification, for electronic codification. I mean, so that's why we took out, because it'll all get different when it gets online.
But if someone's printed out as a PDF. Because people do that quite a bit around here.
Yeah.
They like to print things out. Just to,
Yeah, well, but then that'll cause problems when we do make it electronic. I mean, we could give you guys a PDF that is kind of, that is linked, maybe. If they print it on as paper, though, it's not gonna work.
I'm not sure.
Yeah.
You need to figure out.
And we did go in this with single family, because there was a question asked about tiny homes. And so we are doing our minimum living area must be 1,000 square feet.
Although they're allowed in the mixed.
In the other mixed residential,
Yeah, them are.
but not in our single family. And we've got some homes here that, of course, they're grandfathered in, but they don't meet that.
I just had one question about single family homes. Is there a certain number of people that can live in what is really a single family home? I mean, we've got some issues going on with some houses around the neighborhoods. They're being rented to, lots of people. Put it that way.
A lot of ordinances do contain provisions that state that, no more than X people or no more than X people, or more often it says, all persons living in a single family home, shall be related by, blood, marriage, or lineal, et cetera.
Kind of causes my problem. I live with someone that's not related to me.
Just a roommate though.
You say that, all the people that have to.
No, what I'm saying is, most generally, a single family home is for a family, it would be a parent, it would be maybe okay. If you got a 3-bedroom house, 4-bedroom house, just fill them up, okay, so you got 4 people or whatever, they're 5.
I mean, that'd be the conjunction, either it's a family, I don't know who wants to say how many people you can have in your family. A lot of people have 3 kids in the same bedroom.
Exactly.
But if they're not related by, blood, marriage, or lineal consanguinity, or whatever it is, then you have 10 people living in a rental house.
I'm talking about what's going on next to Pat Maiden right now.
Yeah, I
And
think
it
that's,
looks like about 10 people
I have
living in that house.
Okay, Mayor,
They're all.
if I could, I believe our code addresses occupancy, and that's different from the land development code, as I understand it. We're talking
Yeah.
about construction of houses and how many
Yeah.
square feet. I believe there is a section in our code that addresses how many unrelated
Right.
people can live in a house. And it's been my observation that our town needs to have some requirements for rental housing, both the condition for which it's maintained and.
we tried with minimum maintenance, and that's what taking care of it. No, it's,
Yeah.
no,
Right.
no,
Yeah, so
no.
Commissioner DeVito's correct. That's usually not, that issue is not normally addressed in the land development code.
Or minimum maintenance standards. I brought to the
Yeah.
commission
Well, no, I understand.
a specific ordinance from, I think it was, Palm Coast or a nearby town over on the coast, that had specific requirements for registration of rental properties and making sure that rental properties were correctly maintained. And maybe we want to look at our code and make sure it has, enough standards.
I think that when we get done with this, we absolutely have to do that, because we're finding that happening here more and more, is that people are buying houses from outside the area. they're renting them out.
Yes,
And instead of going to farm worker requirements,
right,
they're allowing that to occur
Yes.
in these houses, and it's creating, and we have an obligation to those homeowners that feel that it's devaluing their property
I agree.
and what it's doing, so. But we definitely need to work on that one.
I'm sorry to get off.
No, that's okay.
The time for admission.
So I wanna make sure in here, that, Mark, when we go to, in the central business district, on page 44, and then going on to 45, where maximum building size is 3,000 square feet, that we currently have a proposal from a developer that this will not impact that or prohibit something such as that to occur.
When we, that's gonna be a PD anyway, right?
It would be,
Well, that would-
but I just wanna make sure that we don't, it would definitely, they would do that, but I just wanna make sure that,
Right. They will not be in central, but once you make it PD, they're not in the central business district.
okay.
Okay.
And then, of course, that we go to page 46, and colors. Facade colors shall be low reflectance, subtle, neutral, or earth tone colors. I know we don't want high intensity, I know we don't want bright colors or
Teal is a
metallic
earth tone, isn't it?
or black, but pastel colors, I mean, everything, if you go to earth tone and neutral, it just is blah. And so have we limited ourselves?
Eye of the beholder.
What did you say?
I said, eye of the beholder.
That if that's something that, would that limit someone from coming in, say if they wanted to do a pale blue, or if they wanted to use a historic color, like you've got your colonial blue or something to that effect, would that prohibit them from being able to do that?
It says
Or on page
four,
46.
four earth tones.
Well, colonial blue is not earth tone.
Oh, I'm saying, it doesn't say, and earth tones, it says and or earth tone.
Earth tone, but it says subtle neutral.
A blue could be considered neutral.
It's all down at the
It is.
So I'm just wondering, I would
Well,
never,
someone can, you know, if you've ever flown into San Francisco, and as you fly into San Francisco, you can see all the pastel homes there. It's quite beautiful,
it
really.
is.
And it's quite a sight from above. That would be subtle to me. Those colors would be, I mean, not to the point
It shouldn't be like,
They're not neon.
yeah.
Yeah,
even like in Key West, places like that, I mean, it's a subtle, there's a subtleness about it.
and I understand pastel, is, but again, it's all in the eye of the beholder, and if everyone is good with that, then we can go. Then that's fine. There was one in here that
Do we have any
I'm almost done.
jump calls?
Permitted uses, so it comes down to page 51, and it says agriculture not involving livestock, but then it has animal hoarding, should that be domestic animal hoarding?
What page?
Page 51.
What's
I mean,
category?
it's over here, permitted uses, and it's for agricultural.
Well, that's, yeah. I think that kind of should be on business.
Everyone is fine with that, I just thought that you say livestock and then animal boarding, could there be some confusion? Don,
Give me the exact site again.
it's on page 51, and it is 3.13 agriculture,
And the permitted use.
permitted uses.
Yeah, it's the top of the page. It just says animal boarding.
Tigers.
Tigers.
Kennel.
Well, you know,
Lions, tigers, and bears.
I mean, I guess you could put something in there that indicates excluding exotic animals or animals that can only be possessed pursuant to permit.
That's too long.
I'm sorry.
So that's too long, though.
Well, I mean, so you know, and you're not bringing up bad points at all. I mean, these things come up, but, you know, you've got horses already on there.
Yeah.
You've got, dog kennels already on there. And then it says animal boarding, so,
That would,
I mean, I guess you could put some defining language
Yeah.
in there.
We could just put parentheses that says, excludes excludes exotic animals.
it'll be on TV with a.
Are you gonna have a definition of what exotic is?
I'll have to see if there, what I'll end up doing, the way the definitions work so that we don't have to create, we reference certain sort of standard planning definitions. I'll have to look at those, see if they're defined. If not, we will have to. We'll have to.
Sounds good.
Have you done all 200 pages yet, or page where I am now?
Yeah, there's 222 pages in the draft.
I'm just, these are things that have come up.
I was just happy because you did, at one point we were going page by page and then you jumped to about 20 pages, so I'm feeling pretty good.
Then we'll go.
Yeah, no one.
Well, then I can be done, there's.
Go ahead.
Is there anything that you have that is particularly, that you're particularly worried about? That you haven't?
Yeah, everything I've just said, that I've been concerned, but I only read it if I was concerned
Yeah.
about it, and I have skipped
Okay.
over quite a bit,
I mean,
I'm glad
Um,
so I can keep up.
no, I think that for the most part, I think for the most part, and if there's anything else, then I'll submit that if the drive-through services on page 79, is that standard language, 3.37.1? Is that kind of standard language and we're not making anything
no, we're not making
more
anything, and we kind of
difficult
went
for,
back and forth.
like the Dunkin' Donuts or something, wanted to come in here, I want to make sure that, we're not doing anything to,
No, this is pretty.
79.
I would like one right there.
79.
Why does that page, I can't tell you how many times I've rotated this page. It
Yeah,
just keeps rotating back.
That's work for you. If one likes doing something about it.
I don't.
79 is personal storage facilities, is that what you're talking about,
Yes,
or
sir.
general
No,
requirements?
this is on drive-through services, general requirements. And I just asked if that, Mark, if that was standard.
Yeah,
That's the standard
I don't think
language.
this is
We're not
particularly.
making anything too difficult.
No, I mean, you have to have, I've had this conversation, first of all, your Orlando code doesn't have any stacking. And I know Charles had talked to me about this, about, well, do we need to put something in? And I said, well, most engineers are gonna, know what proper stacking is, because I don't think so. But then I ended up getting calls from a couple realtors who were trying to size properties, and they told me what use they wanted to put in, and there just would not have been any way to actually fit the amount of stacking they're looking at. And so it's like, yeah, we're gonna have to put something in the code, because you can't, you can't stack, you can't have a drive-in window within 30 feet. It's gotta be 75,
So
80
like this
feet
is,
back.
like with McDonald's right now, I mean, this is
Yeah.
what preclude what they're doing.
Yeah,
This is
no,
Very much.
No, but it's a good point, but Malacca has no such provision, and there's a business that I can make a great product, but they don't have enough on-site room for the stacking, and it ends up stacking on the state road, and,
Donuts.
The donuts, yeah.
That's very risky there.
Right.
Okay, we go to page 91.
Hi, come on in, you can take a seat.
And it says building materials for exterior walls and finishes, and this is for multifamily development, and we're only allowing them to do stucco of an earth tone.
now what are you requiring, where are you now?
On page 91,
Okay, sorry, I missed that.
B,
Yeah,
1A.
this is pretty much your current, this is currently law.
Currently law here or
Yes.
currently law?
In,
Or just because it is?
Sorry.
Meaning natural brick, unpainted or stained, we have some that are painted.
Yeah.
So, I mean, some people might like to smear them or whatever it's called. I'm just asking, more the earth tone bothers me more than anything. That we would not allow them to do any historical colors that might add some flair to it, but hey, if everybody else is okay with that, I will never, and then I think that for the most part, we've gone over the trees, we've done all of that. Penalties, it says down here on page 164, if you go to page 164, down here it says severability, it shall not be held to impair the validity of the ordinance affecting the part enforcement. I have penalties, but I think we've pretty much taken care of that. And I think that's it. Yes, Commissioner?
When Lupita was here, I brought up the issue of marijuana dispensaries, and I was repeatedly told that we had to treat it like a pharmacy.
you have a choice. You exclude, you either exclude them entirely,
Dispensaries or pharmacies.
both, or
You can exclude dispensaries if we were.
right, you can't separate them. If you want to include dispensaries, you got to exclude pharmacies. Otherwise,
The state looks at them as two of us almost.
Same, yeah.
If you provide pharmacies, you have to allow for those dispensaries. Okay? So if you exclude pharmacies, you can exclude dispensaries because they're treated the same. If you allow pharmacies, you have to allow dispensaries.
I think we should just let the issue go.
Okay, so I just was,
Yeah, that's something that's come up several times, especially when they were considering that there was not anything we
well, we
could do
can do
about
that
it.
ahead, and we have to something in place.
Do we have anything else? Thank y'all for,
I see some junk cars in here.
that's a different one.
Okay.
Code of ordinances.
That's in our code of ordinances.
Okay, good.
But you're right, it's not, and that's something that we definitely need to, as Commissioner Burton said, we really need to look at that next. That should be in our next line of work, before us. Just never ends.
Never done.
I
get a question.
No, that's okay. Thank y'all for allowing me the opportunity to go through that. Yes, sir. Are y'all, okay, you're good?
Hey, Mark, if you want to use my office.
sure.
Yeah, that's real important. It is, especially with this.
It's a lot. We got a lot in front of us.
And then of course, in the middle of this, I got a phone call from City Hall. And I'm thinking, everybody from City Hall that should be here is in this room.
Somebody needs checks on it, probably. It's your turn.
Alright, so, wait, Mayor, I did have one more question for Mark Garrett.
Okay, Mark.
Just wait a second. So, Mark, I had one question for you. So, when you put this together, where does your input come from? Like, since we had the workshops, you said you listened to the tapes, whatever. Do you consult or receive documents from members of the public or the commission or the planning commission?
Yeah, we got, input was taken at the meeting, that's why I was listening to those meetings.
No, I'm saying outside of the meeting. Have you had input from commissioners or planning commissioners or members of the public about what should or should not be in this document?
I have had input from people when I've raised the issue. Part of, this goes back to what our original scope of work was, right? We provided this service to you at way below market rate because that is what you guys had budgeted. I explained that when we and just so you know, we did it, that is $20,000. That's what you had budgeted. We normally provide this service for about $150,000. What is the difference? We would have had a very extensive, public input process where we would have, gone out, multiple meetings, done surveys, created websites, done road shows. That's what gets eliminated, right? So.
He was also CC'd on everything that went to Lapido, so he
Yeah, I mean, I know what comments you guys had,
I'm saying, do individual people come to you and ask you to put things in here since the workshops were concluded? That's what I'm asking.
No individual members of the public. I mean, I've had some conversations with people about, when they've been, for example, I had somebody talk to me about properties along Central Avenue, and they happened to want to do something that I knew was going to be taken care of. And so we've had those kind of conversations.
But not with commissioners. I think, is that what you're trying to, Commissioner DeVito, is that what you're trying to get to?
I'm
As
just
a
trying to say,
commissioner individually spoken to you and asked you to put something in here that has not been decided as a collegiate body?
No,
Is that what you're asking?
Yeah.
Okay.
Or the
Okay.
planning board.
Or the planning board?
no, the
Okay.
planning board, not to
Okay.
me.
That, very simple question, that's all I wanted.
Okay, I just didn't understand, I didn't understand what you were asking about
The mayor said.
a public input process. I didn't realize you were asking about individuals coming to.
Mark, thank you for the work you put in, thank you for your tolerance of us, and getting through this, this is a big deal, and, we greatly appreciate it, and this is a tremendous amount of work, and, we appreciate that.
Thank you, and we're getting close. I can feel it. We're getting close.
We're close, we're close. I have a gentleman here, I'm gonna ask him, sir, can we help you?
No, he's meeting
Oh,
tomorrow.
you're meeting Mark, okay.
Yeah, I
Okay. He looked like he was a little eager, so I was like, okay. Good luck, thank y'all.
So, you can go to the next item.
Yep, let's go to the
So,
next item.
we've sent you 8 resumes that we've received. My recommendation is just to schedule them all on a day and do maybe 30-minute interviews. They can either come in live or we can Zoom them in and go through an afternoon, 2 afternoons, and then make a decision. The most recent one we got was from, he really has no experience in local government, correctional officer, but the others all, some have rather extensive experience.
This one's gonna be retired, they're gonna come out of retirement to help us out for a lot, it seems like.
Yeah, a few of them have said, indicated they will apply for the permanent, some may not, and just help us out in the interim.
And I looked up the ad on FCCMA, and it says very anything.
It's actually the second one I sent, like, the first one, actually you fill out a form
Right.
and send it in, I got no response, so I filled it out again, thinking maybe it didn't submit, and then that's all that ended up there.
Now, is there, I mean, I don't know, it just says we're looking for an interim city manager that could apply for a permanent position, and that's about it. I mean,
Yeah, I didn't feel I could put any salary,
but, sorry.
compensation or anything there.
There's not really a lot of that in there, I don't know. I was surprised that it was so bare bones.
Well, it couldn't because we hadn't discussed it and decided on the salary range to
No, I know.
allow him, so we probably.
But it does no other,
Right.
no other.
And it also went out directly to a list of, what's called MIT's, managers in transition, that, they sent it directly to them, they maintain a list. So that's probably where most of the applicants came from.
I think city managers, advertising city manager for the most part, those that are in that field, they have a general understanding of what's required.
So when we do our larger search, we have a lot of other resources we can tap.
Yeah, and I have scheduled, the senior advisors to come in on September 12th to present to you that process, and get your approval to move forward.
Which one?
It's, George is not available, it's, I can't remember the name of the other guy that's coming.
Do we want to look at a date? I think we need to go ahead.
Yeah, you need to pick a date.
Yes, I have a-
Commissioner DeVito?
Yeah, I have a question. So a couple of things. In between now and when we schedule the date, is it possible for the people that we're interviewing, to ask them to provide references? Their salary, because not all provided references. And to ask them for permission to do a background and financial check, because don't we really want to have that done when we're considering them?
We can certainly request it.
Typically, we've done that after the fact, after we've approved them, they have to make sure that the background check.
Well, the policies I've seen used in the past are, you would only do that to your short list.
Well,
So if you interview 7 and decide that just 4 of them, for whatever reason, you're not gonna work with, then I'd hate to see you do background checks and all that other things on the full 7, and then
but my concern is this kind of is a short list because it's a short time frame, and,
Well, I know one of them probably won't even qualify, doesn't even qualify, so.
okay, but, and my suggestion about the very last submission that we got, I don't think that person meets any kind of minimum qualification. I was going to suggest, that we send a nice letter of thanks for the application and encourage them to apply for, other positions that we might have, because I don't think it's realistic, that I think we have people in-house who would be more appropriate. So, and I don't see a need, I think we need to concentrate on, and the other question to ask people, I think, before we even interview them, if they could do like a supplemental, submission, would be, when are they available and how long could they, remain with us? Because, we didn't give a specific start date, did we?
Just, I said, ideally, we'd like to get them in 2 weeks about the second week, third week of September, so we had 2 weeks with me. Ideally, less ideal would be only a week with me.
Sure, but I didn't see that in the ad.
That was in the email to the MITs, not in the ad. And then anybody who sent me a resume, I sent out to them the process that you would be having interviews early September, with the intention of starting
In
mid-September.
my experience with the job interviews we've done before, to me, it would be helpful to ask them to respond to that, because sometimes you get people who come to the interview and they're hoping we'll work with them or whatnot. It would be nice to have it just on the table, just tell us.
If you select a date, I can ask them, tell them the date, ask them to pick 3 times frames to choose from. So I can schedule them and ask them to provide that information, references if they have not, their salary requirements, or if they need living allowance, those other information to provide back, and then I'll get that to you for the date of your interviews, which I was hoping would be maybe the first week of September.
I agree with that. I think Charles, that we leave that up to you and your discussion with them on an individual basis, as to when they can start, and if you need to eliminate them from the interview process because of, then you could do that.
So everybody's saying if they can't start at least a week before Charles.
Yeah.
Then I think
At
we
least it
should,
says Monday, September 15th, right, we want,
Ideally, we get
16th.
2 weeks before.
Yeah, the 16th is that Monday, is the Monday. And then.
Whenever he can,
With that, that's 2 weeks, so I'll be.
the more time they can spend with Charles, the better,
It's gonna
the
be
better,
better for us.
the better for us that it would be. So, and I think, you might be able to eliminate some of them just based on that. You'll kind of know, you kind of probably have an idea with your salary. If they're asking for,
I'll tell them we'll do it, like you did before, you did a monthly contractual amount.
that's
So
what
that
we
was
did with our
having, it
interim,
was
yeah.
aggressive in that in terms, what they would require monthly and how long they could stay. I told them that the selection would probably occur after the national elections. So they would need to stay at least through November.
Oh, at least.
Yeah.
And at least, it should be there.
one thing I was thinking about, I was a little concerned is, should we decide on some kind of salary range, before we hear what they have in mind. I think previously we came up with a ballpark figure that we would be considering. I didn't know if Charles had something to recommend.
Yeah, Charles, I know you've given that some thought. So do you have a recommendation to us that we could give you a range to tell them that this is gonna be the range monthly, and if this doesn't work for you again, that will eliminate that?
But let me say this now, we understand, we want somebody that's qualified, we just don't wanna think you're gonna get somebody to uproot and move here and don't pay them a good salary.
Right.
Cause you can, go to the newspaper, look in different areas, and you see where these people are leaving the job, the kind of job that they have, they're leaving.
Problem right now
It's
is.
completely, trying to hide.
That's why I'm asking, does the city manager have a range in mind?
I was calculating, about 8,300 a month.
Okay.
That's an annual salary of about $100,000.
Yeah, we got to pay people.
Yeah,
And I
we
keep
do.
on saying.
I'm growing at 99.
You're at 99?
Right, but do you pay more for a short-term temporary spot?
Sometimes you do.
So so I've been through a few
You've
city
been
managers.
there, you've done this. Right.
You might wanna leave the salary negotiable right now. Throw a number out there, you may turn some people off. You may get somebody walking the door, you say that's not, I don't pay them this much, but we think we better grab that person while we can. If it were me, I would say salary negotiable.
And I think the level of experience that some of these candidates have,
That's
they're
good.
gonna understand
Yeah.
that, they're not walking into this blind. Some of them have been interim city managers before. I think they pretty much know what's going on. And once we interview them, they love them.
I'll ask them to give us a number.
That's good.
Yeah, but everybody else,
Just so you have that, because when they're contractual, we're not paying, they're a 1099, they would be a 1099, and so we wouldn't be paying their health insurance, we wouldn't be paying the car allowance, we wouldn't be paying, all that stuff, and also that we don't take into account when we're looking at just his salary dollars.
You guys want to pick a date?
Yeah. Yes.
Coach,
So for the 4th?
I was interested at, the major that we had and how much money they invested in just a regular office.
Yeah.
Yeah, almost $80-some thousand in a regular police office. And they told us to get it. So
So the fifth,
Well, I was looking at Thursday the 5th, if that is possible, because,
All afternoon, just like start at 1 o'clock.
well, yeah, 1 o'clock.
or whenever they can.
No, they have to be one on.
I let them choose, I give them, say, give me 3 time frames and then I can sort them out. So if you think there'll be seven interviews?
I was looking through these already, and there are some that, you can kind of already eliminate, I think, but.
Well, I would like to know that, because to me, I would rather focus our available time on the people.
That we actually, because even the ones that you've already given us, I think that we could kind of start to focus or bring that down a little bit, but that's me.
Well,
You have someone that,
I guess to me,
you don't think,
if Commissioner Burton, there's one person that I am doubtful about interviewing. But I think if we all share the same, I guess we don't feel that person.
I don't want to waste their time, and I don't want to waste our time.
Exactly.
That's
I-
fine.
So who would you like, who are y'all considering that was not,
Especially the last one, you know that, right?
well, yeah, the one,
Right,
I
so
think that's.
number 6 and as well, and we have to keep it Christopher Edwards. Right, I'm looking at the city manager's, list that he numbered. I would potentially not interview the out-of-state candidate simply because Florida law is so specific. But being realistic, I have to keep in mind that sometimes between now and the interview date or after the interview, people drop out. I mean,
So who would you be willing to interview? Yes.
well, I'm most interested in the first 5, plus, I guess, the formerly retired, very capable Mr. Barnard. And I think John Drago may have applied here before, I'm not positive. I think,
That sounds familiar to me, he didn't sound familiar.
He's from Longwood, he's actually my first choice, is, but that's just my
Okay,
opinion.
so-
Charles, the,
Okay, I got a lot of conversations, one person at a time, guys.
okay, so I was saying, I said I would cut
You
it
need-
down to
Do you
5.
need any more legal advice?
No, sir, we're good.
Yes, I do. I have one question.
Okay.
Circulated, I found it interesting, the top person on the list, Jack Butler. He has a private development company, and maybe you could tell us this later. His resume includes, it looks like city employment that he's held at the interim manager and assistant manager of Town of Oakland. He says he's managing member of Butler and Butler self-employed for the past 22 years. He provides services to government agencies and private sector clients. So, I mean, I don't need an answer to this now, but I don't know what the relationship between his private development business and his relationship with cities is. And would he be here part-time or whatever, anyway?
Well, I don't know either. I mean, I'm looking at, it looks like he's a certified residential building contractor.
Can I say something, maybe this will end this conversation, Jack Butler, I looked him up and don't be afraid to get right on and look him up in Google, Google. But Jack Butler was an interim manager for 1 month and, got fired, okay? And basically because, what I read, because he couldn't get along with the mayor. So if he couldn't get along with the mayor, he probably couldn't get along with the commission. So I just wanna throw that out there. Don't be afraid to look further than just these pages, that's all.
Right,
A
well,
lot of information on these people.
right, so essentially, as I said,
I just thought it was great. I had to throw it in.
All I would advise against is saying too much
yes,
up here. Go ahead and agree to interview him or don't. But remember that what you're saying is being recorded. I don't know if you're on.
Yeah, we are.
Yes.
So, maybe the less said the better
Yes, thank you.
at this stage. Okay?
Thank you, Don.
All right, thank
Have a
you.
great day.
And I think with that, that we can go ahead and set up an interview with all of those that have talked to them or still interested. That would be my recommendation, and that would be a very safe, I would say though, for, I can't pronounce it. The last, yeah, yes, I was looking at the last name, making sure I didn't slaughter it.
Doesn't make that complicated.
She just, not that you have to have been a city manager, I mean, you were not, Phil Leary had not been a city manager, Mike Esposito had not been a city manager. So we need to make sure that, but I don't know that she meets the criterion, so.
well, that's why, Mayor, I would, my strong suggestion is to send her, because she is local, a nice letter of thanks, encouraging her to apply in future. Because I don't want to discourage anyone, but I think we do need to make sure we are looking at people who have the requisite.
Are you okay with top 30 minutes each?
Yes. And if we're gonna do by Zoom, can we get some speakers for that?
Yeah,
Is somebody on the phone here?
Yeah, my
Oh, okay.
So y'all are sure that you want to interview the 6th person on the list?
When you say 6, would you please use?
Christopher Edwards.
Okay, Christopher Edwards. I mean, I don't have a problem interviewing him, absolutely
Yeah,
not.
I don't.
same as mine.
He's local and he's got economic, I mean, that's a lot of Charles's background, so I don't have a problem with him.
They're not gonna be able to get on these calls.
No, we're not,
Okay, just like you're not trying to, like, we play them.
believe me, if anybody knows more than I have, so.
Okay, so we're interviewing 7 people.
7, see if some drop out, it's less,
Daytona,
Daytona.
yeah. He's out of the Daytona area.
I'm assuming the parentheses is where they live right now, that was what.
Yes, yeah.
So we're doing September 5th, you said at 1 o'clock?
Starting at 1 o'clock. On the first interview schedule at 1. And I'll let them know they can come here if they're a little close enough, or they can zoom in.
And, you know.
And after you talk to them, Charles, they might, once they, some of them might decide to drop out, some of them might be real excited about it, so.
September 5th.
Yes, sir, 1 o'clock, Karen,
I was trying to, you know, check this out.
I'll make a note here too, call Commissioner.
Yeah.
Yes.
You're asking where?
Yeah. That's a bus out.
Okay, let's talk about it.
Right off the lights in, right off the
Okay,
lights
let's
in.
keep it.
It's known for it's gonna be long-term location of a state mental.
It was a
facility.
mental facility back in.
Actually, it's for forensic commitments.
Okay.
A lot of health care.
But back in the day.
Exactly.
didn't
What
want
he
to
did?
do it. Yeah, he was city manager for,
For the mental.
no,
Actually, no, that was necessary.
city. Okay, with that, can I get a motion to
I
adjourn?
move.
I'll second it.
Okay, we have a motion and a second, all in favor, say aye.
Aye.